Your Honor, we are live and ready to begin.
Okay, thank you very much. Are the attorneys for Stanley, the prosecution, prepared to proceed?
Yes, Your Honor, but before we proceed, we have some preliminary matters we'd like to attend.
We'll address those here in a second when we get to after everybody gets sworn in. Are the attorneys for Holly ready to proceed?
Yes, Your Honor. Your Honor, would you be comfortable with us introducing ourselves as well?
We will do that. We got to get through some preliminary matters first, but we're going to get to all of that.
Of course, Your Honor. We are ready.
Okay, thank you. Before we begin, I want to remind the teams that no recesses will be allowed with the exception of those granted for a health emergency, and especially not between the end of witness examination and the beginning of closing arguments. As our courtroom monitor indicated, we are on a hard stop at 4 o'clock today. So be mindful of that. And if necessary, we will take steps to speed testimony and or argument along if necessary. Do any of the teams have an objection to any of the scoring panelists at this time? Stanley?
No, Your Honor.
Holly?
No, Your Honor.
Okay. I want to remind the teams and coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. Remind the teams that their compliance with the time requirements will be considered in scoring individual performances. I want to confirm that there's no no coach or team member in the room with any of you other than yourselves. Is that, and the Stanley attorneys, you're in the room, just the four of you plus your witnesses?
Yes, Your Honor.
Okay. At this point, I would like each side to introduce their participating team members, starting with the prosecution of Stanley.
Your Honor, prior to introducing ourselves, would you like our timekeeper to post a roster in the chat?
We have the rosters.
Yes, Your Honor. My name is Mark Clinton. I will be presenting the opening statement, conducting the direct examination of Dr. Casey Rogers, and the cross-examination of Skylar Weirs.
Good afternoon. My name is Eva Simpson. I'll be conducting the direct examination of Carson Durst and the cross-examination of Dr. Devin Williams.
Good afternoon. My name is Hannah Feeney. I will be conducting the direct examination of Dakota Weirs, the cross-examination of Blake Doncourt, and presenting the closing argument. May our witnesses now introduce themselves?
Yes, please.
Good afternoon. My name is Caitlin Brennan, and I am Dr. Casey Rogers.
Good afternoon. My name is Bailey Burton, and I am Carson Durst.
Good afternoon. My name is Hayden Clausen, and I am Dakota Weirs.
Thank you. Ms. Wu, would you like to introduce yourself and the attorneys for the defense?
Yes, Your Honor. Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Angela Wu. I'll be conducting the direct examination of Blake Doncourt, the cross-examination of Dakota Weirs, as well as performing the closing argument.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Kayla Caniglio, and I'll be conducting the direct examination of Skylar Weirs and the cross-examination of Dr. Casey Rogers.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Taryn McDermott, and I will be giving the opening statement as well as delivering the cross-examination of Carson Durst and the direct examination of Dr. Devin Williams. Your Honor, permission to have our witnesses introduce themselves?
Yes, please.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Jamie Williamson, and I am Blake Doncourt.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Donna Shaw, and I am Skylar Weirs.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Mark Klinko, and I am Dr. Devin Williams.
Thank you, everyone. At this point in time, we're going to swear in the members of all teams. Would the team members please raise your right hands? Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Thank you. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Okay, you can put your hands down. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? Okay, great, thank you. Before we begin, and I know we have some preliminary matters to deal with, but before we begin, I want to just, for the purposes of this, because this is on Zoom, I'm going to have I'd like the panelists to keep their video active during opening statements and closing statements, and just please close the video portion of your, or please close or mute your video, I guess is what it would be called, during the witness testimony. During witness questioning, I would like the attorneys who are conducting the direct and cross-examination to keep their videos active, with the rest of the remainder of the parties, or maybe the attorneys, mute their video, and witnesses, their video should be active only when they are testifying. Does everybody understand? Okay, great, thank you. Attorneys for the prosecution, Mr. Winston, you indicated that you had some preliminary matters that you'd like to address. Would you like to address those now?
Yes, Your Honor. First, we would like to instruct the court and the scoring journalists that for the best possible experience, putting your video into gallery view, as only one mic on our side is going to be picking up audio. If it is in speaker view, you will only be able to see the attorney camera and not the witness camera at the same time.
Okay, thank you.
The plaintiff has made the efforts to be in an area with the best possible internet. However, if at any time Your Honor or any of the scoring journalists cannot hear or see us, feel free to interrupt us at any time.
Will do.
Next, we request that Dakota Weirs be our advisory witness, as he is the plaintiff in today's case, and therefore be seated at counsel table.
That's fine.
For the record, there will be no witness sequestration pursuant to Rule 5.3.1 of the Rules of Competition, and all witnesses will be present for all testimony in today's case.
Understood.
At this time, may my trial technician post a copy of the stipulations, court-approved jury instructions, and Your Honor's pre-trial ruling in the chat. Your Honor, you may be muted. I cannot hear you.
Sorry, I didn't want you to hear my dog barking. I already have copies of those. You're free to post them in the chat, but it's not necessary.
As I indicated before trial started, we wish to introduce two new stipulations. The first one being that Lush Fertilizer manufactures a chemical compound known as Drufo that is in their products. And the second one being admission of Exhibit 1, as we have a good faith belief that it will be entered into evidence in today's trial.
Would one of the attorneys from the defense like to address those stipulations?
Yes, Your Honor. The defense does not object to the first stipulation. However, we do object to the second stipulation, and we would prefer that all exhibits follow the course of normal admission into evidence.
With that being said, then the first stipulation that Lush manufactures Drufo and uses it in its products is accepted as a stipulation in the hearing or in the trial. Anything further, Mr. Winston?
Yes, may my trial technician post that third stipulation into the chat?
That's fine.
Can the court clarify whether it intends to read the jury instructions prior to or after a closing argument?
We haven't been reading them, so
Constructively read your honor.
The jury would be read the jury instructions after closing argument.
For clarification, are we permitted to use the jury instructions during the course of our closing argument?
You are.
Was that we are allowed, Your Honor?
Yes, you are allowed. I'm sorry. Yes, you may do so.
And this time, we would like to clarify the mechanisms and procedures of this online trial. We request that pursuant to Rule 7.4, that all witnesses must have all case materials in front of them. We request that all witnesses have all of the exhibits as well as their affidavit face down in front of them so that it may be referenced at any time by counsel when directed. And we will make it clear which witness or which exhibit or witness statement we are referencing at that time.
Ms. Wu, would you have any response to that?
Your Honor, just one small thing. I would just like to clarify Given that opposing counsel is all seated in one room, I would like to clarify if they would be using screen share to share exhibits as indicated in the rules.
Okay, we'll deal with that first, but he was asking the issue of having the witnesses have all the documents in front of them face down. Do you have any issues with that?
No objections, Your Honor.
Okay, so that will be permitted if the witnesses should have all the exhibits available to them and face down in front of them and not reference them unless otherwise necessary or appropriate during the hearing. Mr. Winston, anything further?
Just for clarifications, we'll be publishing exhibits after admission by screen sharing, as well as posting a copy in the chat so that everyone may reference.
Okay, thank you.
We ask permission to move about our virtual well during examinations, as well as during opening statement and closing argument.
That's fine.
Finally, Your Honor, we ask that any time at the end of our closing argument be reserved for rebuttal.
You're going to need to make that request at the beginning of rebuttal.
At the beginning of closing, or when we?
At the beginning of the closing, excuse me. Yes, at the beginning of your closing, if you want to reserve time, just remind the timekeeper at that point. You'll be permitted to reserve time, but just remind the timekeeper at the time of your closing statement.
With that, Your Honor, the plaintiff is ready to proceed to trial.
For the defense, are there any preliminary issues?
Yes, Your Honor. Your Honor, for the defense, we request that exhibits be shown by screen share as they're being authenticated by the witness and that they are not constructively admitted into evidence at that time.
Well, they're not going to be admitted until their foundation is laid and a request is made for admission.
Yes, Your Honor.
Okay, I just want to make sure I understood what you're asking. Yes.
Yes, Your Honor. Your Honor, in addition, we ask that exhibits be deemed automatically published to the jury as they are admitted into evidence.
Mr. Winston, or Winton, excuse me. Do you have a response to that?
We would request that counsel make the request to publish prior to publishing.
I'm going to require counsel to request publication.
Yes, Your Honor.
Yes, Your Honor. Your Honor, we ask that timers be allowed to communicate using the Zoom chat feature to avoid time discrepancies.
Yes, that is expected.
And Your Honor, because the defense is all virtual, we would ask that timers be allowed to post the time remaining in the chat.
Yes, that's permitted. That's how it's been done thus far. So.
Yes, Your Honor.
Okay.
Your Honor, we request that in the case someone is disconnected, they would be able to text another teammate to communicate the situation, but only then could text be used.
Yes, I'll permit that. If somebody gets disconnected, they need to be and they can't get reconnected. Our courtroom monitor has posted her phone number in the chat as well for technical difficulties, as well as the Zoom phone number. So they need to communicate with, I guess, your team members to allow them, for the sole purpose of letting them know they've been disconnected, and also contact the courtroom monitor.
Yes, Your Honor. No further preliminary matters for the defense.
Just a second to get back to my list. All right. Is the prosecution prepared to proceed?
Yes, Your Honor.
Okay. And who will be delivering? And Mr. Winton, you'll be delivering the opening statement?
Yes, Your Honor.
Okay. You may proceed.
May it please the court.
Go ahead.
Dave's case is about profits being put before people. This is Dakota Weirs. He's 20 years old and he has been diagnosed with non-Hodgkin's lymphoma. He will have to sit here today, suffering and in pain. He has chest pains and shortness of breath, and he is tired all the time. But it wasn't always like this. He used to play piano, and he was good. So good, in fact, that he got a full ride scholarship to Juilliard. He grew up with his twin brother, Skylar Weirs. They did everything together, at least until Dakota was 14. That's when he took a job at Havens Landscaping, working with Lush fertilizer. After years of working with their product, he realized that something was wrong. The diagnosis changed everything and crushed many of his hopes and dreams. Lush Fertilizer prioritized profits over people, and it cost Dakota Weirs his future. As the plaintiff in today's case, we have the burden of proof. We have to prove that it's more likely than not that Lush Fertilizer negligently caused Dakota Weirs' non-Hodgkin's lymphoma with their product. And because of that, Dakota suffered non-economic damages, including mental and physical pain and suffering, emotional trauma, emotional stress, distress, inconvenience, and impairment to his quality of life. We will meet our verdict because Lush Fertilizer prioritized profits over people, and now they need to be held accountable. As you listen to the testimony in today's case, you will learn that Lush Fertilizer contains a compound called drufa. This is the secret to their success, as it's an incredibly powerful bonding agent. You will also hear from a former employee of Lush, Ms. Carson Durst. She will tell you that Lush Fertilizer knew that their product caused cancer, but chose to release it anyways. You will also learn that Lush Fertilizer knew how to make their product safe. All that they had to do was bake it. Their CEO, Blake Doncourt, thought that it was just too expensive. Once again, Lush Fertilizer prioritized profits over people, and today you get to hold them accountable. As you listen to testimony, keep in mind that the defense has their own burden. Instead of simply saying that their product does not cause cancer, they have instead asserted that Dakota Weirs is responsible for his own cancer because of the way that he used their product. They will have to prove by preponderance of the evidence the way in which Dakota used the product was unreasonable. More importantly, that if used in the way that the defense says is reasonable, that would limit their product's ability to cause cancer. As you listen to the testimony, ask yourself why the defense chose to call a 20-year-old journalist if they otherwise had a real expert to tell you that the product is safe. You will also hear from Dr. Casey Rogers, a toxicologist and the only credible expert in today's case. She will tell you that she conducted a study on the effectiveness of the personal protective gear that the defense recommends. The results of her study are inconclusive, meaning the science will not allow the defense to meet their burden, and blaming the victim just won't work. All that Dakota Weirs wants is to regain a small portion of what their company took from him. The maximum that we can ask for by law is $500,000 in non-economic damages. That is nothing compared to the suffering that Dakota has had to go through, and very little compared to what Lush makes now. At the end of today's trial, my co-counsel, Ms. Feeney, will stand before you and ask that you return the verdict, finding Lush Fertilizer solely negligent for prioritizing profits over people, and award Dakota Weirs $500,000 in non-economic damages. Thank you.
Thank you, Mr. Winton. Ms. McDermott?
Yes, Your Honor. May it appease the court?
May proceed.
Speculation versus science. Your Honor, members of the jury, the plaintiff is bringing fragmented pieces of information. They're trying to put together a puzzle where the pieces simply don't fit. And with this fragmented information, they are speculating on the cause of the plaintiff's illness while ignoring the years of science behind the chemical compound drufa. The plaintiff is speculating that Lush Fertilizer caused her condition while ignoring the years of science that proves the exact opposite. While the defense is sorry that the plaintiff is in this situation, Lush Fertilizer is not the company that should be here today. Lush was founded in 2001 by Blake Doncourt, a young woman who simply wanted to make the world a greener and healthier place. She saw what fertilizers were doing to the environment, and she wanted to change that. So she, along with a team of researchers, came up with the revolutionary product, Drufo. This product is keeping synthetic nitrogen out of the soil, out of the water, and out of you. This is keeping people safe. And today, the defense will prove to you that there's no causal link between Drufo and non-Hodgkin lymphoma. Throughout the course of today's trial, consider the science behind the plaintiff's case, or lack thereof. The plaintiff saw one news story and zeroed in on Lush Fertilizer while ignoring the years of science behind their products. In contrast, compare the science behind the defense's case. Today, the defense will be calling 3 witnesses: Blake Doncourt, Skylar Weirs, and Dr. Devin Williams. Ms. Doncourt, the CEO of Lush Fertilizer, will testify to the fact that her company conducted studies over the course of years to ensure the safety of their products, and that these studies showed that non-Hodgkin lymphoma was not a specific risk. She will also testify to the labels that are on her products, and that these labels are there to keep her customers safe from all fertilizers. And that these labels aren't just approved by Lush Fertilizer, they're approved by the EPA, and that is science. Next, Ms. Skylar Weirs, a young woman who spent time investigating Drufo. She will testify to her extensive research that shows that Lush Fertilizer is safer than almost all products on the market because of Drufo. And she will also testify to the fact that her research shows there's no link between Drufo and cancer, and that is science. Finally, Dr. Devin Williams, the lead product and development engineer at Lush Fertilizer. He will testify to the studies that his team has conducted that shows there's no statistical correlation between Drufo and non-Hodgkin lymphoma. Today, the plaintiff has the burden of proof, which they must prove via the preponderance of the evidence, which simply means more likely than not. The defense counters with a claim of negligence, a claim against Mr. Weirs, who did not take the proper precautions, not only with Lush, but with all of the other fertilizers he used. And with the affirmative defense and comparative fault, the defense will show that the plaintiff was negligent in his use of all fertilizers. Today, the defense asks that you find Lush Fertilizer not liable. In addition, the defense asks that you find the plaintiff liable for negligence. Thank you.
Thank you, Ms. McDermott. How would the plaintiff like to proceed?
Yes, Your Honor. The plaintiff calls Dr. Casey Rogers to the stand.
Dr. Rogers?
Your Honor, before I proceed with my direct examination, may I be allowed 1 moment to take care of a brief technical issue?
That's fine. Okay, you can proceed.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. I'm Dr. Casey Rogers. I'm a toxicologist.
And what exactly was your role in today's case?
I was looking at Lush Fertilizer, one of their products, Drufo, and using my research and expertise to determine what their connection was to the cancer of Mr. Dakota Weirs.
Could you take a look at Exhibit 6 and 7? They should be placed in front of you. What are these?
Exhibit 6 is a copy of my current curriculum vitae, and Exhibit 7 is a list of my publications.
And is it a regular part of your job to keep both of these up to date?
Yes,
And are they both fair and accurate to the best of your knowledge?
they are.
Your Honor, at this time, I move to admit Exhibit 6 and 7 into evidence.
Mr. Coniglio?
The defense has no objection, Your Honor.
So Exhibit 6 and Exhibit 7 will be admitted.
Your Honor, may my trial technician publish to the jury?
Yes.
Now, Dr. Rogers, starting with Exhibit 6, could you explain what your current occupation is?
I am a professor in the Horticulture and Entomology Department at the University of California at Berkeley. I'm also a faculty researcher in the Environmental Chemistry and Toxicology lab there.
And still looking at Exhibit 6, could you walk us through your education?
Of course. I earned my bachelor's degree in agriculture and chemistry from Colorado State University, and then I was a research analyst for many years before earning my PhD in agriculture and entomology from UC Berkeley.
Thank you, trial technician. Could you move to Exhibit 7? Dr. Rogers, could you tell us about the research on this exhibit?
As you can see, I have quite a lot of publications to my name. Many of them actually concern Drufo.
Thank you, trial technician. You may take down the exhibit. Dr. Rogers, you mentioned being a toxicologist. Could you explain what that is?
The toxicologist looks at the negative health effects that might arise from being exposed to certain chemicals or toxins. This often means that we look at an individual situation, any symptoms or diseases they might have, and work backwards until we can find out the cause of those symptoms or disease.
Now, without stating any expert opinion, did you come to an expert conclusion in today's case?
Yes, I did.
Your Honor, at this time, we ask that Dr. Casey Rogers be admitted as an expert in the field of toxicology.
Niglio,
Your Honor, permission to conduct a voir dire on the witness.
you may proceed.
Good afternoon, Dr. Rogers.
Good afternoon.
You have no education in the medical field, do you?
I work as a toxicologist, but I do not have a specific medical degree now.
And you have not had any training in the field of medicine, have you?
The field of medicine is very broad. I'm not sure what you're referring to.
Have you had any sort of training in any part of the medical field? You have not, have you?
Yes, I have. I'm a toxicologist. I look at the effects that certain chemicals can have on the human body.
But being a toxicologist is not any form of medicine, correct, Dr. Rogers?
In a way it is, but if you're talking about diagnosing patients, that is not what I do.
Dr. Rogers, I have a limited time here, so I'm going to ask you a series of yes or no questions about your qualifications. Isn't it true that you have not worked specifically in the medical field pursuant to diagnoses, correct?
I do not diagnose patients.
And you have had no education in the field of toxicology, correct?
I have worked as a toxicologist for 20 years or so.
Dr. Rogers, that was not the question I asked you. The question I asked you is if you had any education in the form of toxicology.
I do not have a degree in toxicology. I have degrees in agriculture, chemistry, and entomology.
Thank you, Dr. Rogers. Your Honor, the defense objects to the witness being an expert in the field of toxicology, as she has had no education within that field. Furthermore, if she does get in as an expert in the field of toxicology, the defense asks to have her expertise limited to not being able to diagnose any sort of medical conditions or make any sort of conclusions as to what caused those medical conditions.
Mr. Winton, would you like to respond?
Pursuant to the rule 702, all that is needed to qualify a witness as an expert is experience, knowledge, specialized training, or education. Dr. Rogers has testified to having knowledge and specialized training. She only needed one of those, but she has both. Therefore, she does meet the requirements of 702 to be tendered as an expert in toxicology. Furthermore, toxicology is a broad field that encompasses not the diagnosis, but the looking at previously diagnosed conditions and the possible causes of those conditions, as long as they are environmentally caused conditions like non-Hodgkin's lymphoma.
I apologize. Dr. Rogers is going to, the objection is overruled. Dr. Rogers will be admitted in the field of toxicology.
Yes, Your Honor.
Proceed, Mr. Winton.
You mentioned having concerns about Lush fertilizer, specifically the compound Drufo. When did your concerns first arise?
It was in the mid-2000s when the product was first released to the market. It seemed as if sufficient safety studies had not been done on the product.
Objection, Your Honor. Speculation.
What was the question again?
When did your concerns about Drufo first arise?
Objections overruled.
Dr. Rogers, did you get a chance to finish your answer?
I was just saying that it seemed as if sufficient safety studies had not been done on the product due to the short amount of time in which the safety studies were conducted. So only a few years after the product was released, I began doing my own research.
Could you tell us a little bit about that?
Of course. As I said earlier, I've done multiple studies on Drufo, but I'm going to talk about one in particular today, and it actually has two separate parts.
Okay, let's start with the first part of that study. What was the goal of it?
The goal was to determine if there was a link between using Drufo in Lush fertilizer and being diagnosed with cancer of any sort. And if there was a link, how strong that link was.
And how did you go about determining if there was a link?
I set up 3 different groups and monitored them for a period of time. The first group had a high level of exposure to Drufo. These were farm laborers and other agricultural workers. The second group had more moderate exposure to Drufo, like casual gardeners. And the third group had no exposure to Drufo. And this is my control group.
And just to clarify, what exactly does exposure mean in the context of this study?
To be exposed to something means to be in contact with it, especially through touching it or breathing it in.
And what were the results of your study?
Unfortunately, the people that were exposed to Drufo the most often were found to be 10 times more likely to be diagnosed with cancer as the control group, and 5 times more likely to be diagnosed with cancer as the group with moderate exposure.
And did your study identify the types of cancers typically associated with the use of Drufo?
Yes, it was often endocrine and exocrine cancers. An example of an exocrine cancer is non-Hodgkin.
Objection, Your Honor. Outside the scope of the witness's expertise.
Overruled.
Dr. Rogers, did you get a chance to finish your answer?
I believe I was just saying that an example of an exocrine cancer is non-Hodgkin's lymphoma, which is also an environmental cancer.
Now, when doing your research for this study, did you come across any other studies with similar results to yours?
Yes, I did.
Could you take a look at Exhibit 3, which should be in front of you? What is this?
This is the study I found that was released in England.
And is this a fair and accurate copy of the study as you found it?
Yes, it is.
And do other experts in your field reasonably rely upon studies from other experts to base their conclusions?
Of course.
Your Honor, at this time I move to admit Exhibit 3 into evidence.
Ms. Coniglio?
Your Honor, the defense objects to hearsay as well as Rule 403 under misleading the jury.
How is it misleading?
Your Honor, this is a study performed on rats, not on people, and the witness has not been given any sort of credibility to tie the link between cancer within a person and cancer within an animal, specifically rats. So the idea that this study could link a possible carcinogen to rats without any sort of qualifications to back up that link in court today would be misleading the jury as to Drufo's carcinogen qualities or lack thereof.
Okay.
Your Honor, may I respond?
Yes, you may respond.
As pursuant to the hearsay objection, that this falls under the exception of 703, as Dr. Rogers has been tendered as an expert in toxicology and has expressed that these sorts of studies are things that would reasonably be relied upon by other experts in her field. Furthermore, the probative value of the jury understanding that there was knowledge of this substance being possibly carcinogenic and that Lush Fertilizer would have had knowledge of this far outweighs the danger of prejudice. And the fact that the study was conducted on rats goes to the weight that the jury should give this, not its admissibility.
I agree. The objection's overruled. Exhibit 3 will be admitted.
Your Honor, may my timekeeper or my trial technician publish by dropping a file in the chat?
Yes.
We'll come to that a little bit later in the case, but could you briefly explain what it is?
The study says that Drufo is carcinogenic in rats. Carcinogenic means cancer causing.
Now, you mentioned that this was a two-part study. Let's move to that second part. What was the goal of this part?
I believe we're going back to my original study. The second part of my study was to determine whether or not wearing protective equipment would have done anything to limit the risks of using Drufo.
And what were the results of the second part of your study?
They were actually inconclusive.
What does that mean?
It means that there is really no way to tell whether using protective equipment would have done any good.
And why was your study deemed inconclusive?
There were a couple of reasons. First, there wasn't a sufficient amount of time to determine whether or not the protective equipment was beneficial. And second, workers aren't usually provided with protective equipment in the agri-tech industry.
So I want to move on and I want to talk a little bit about how all of that relates to Dakota Weirs' case. Did you review anything in particular about Dakota Weirs' cancer?
Yes, I reviewed his medical records and employment records.
And are these types of records the things that members of your field would reasonably rely upon?
Absolutely. Toxicologists have to have a holistic understanding of each situation in order to come to the most accurate conclusion about the cause of someone's disease.
And what did you learn from looking at Dakota Weirs' medical records?
I learned that he'd been diagnosed with
Objection, Your Honor. Hearsay?
Overruled.
Did you get a chance to finish your answer?
Dakota Weirs had been diagnosed with non-Hodgkin's lymphoma only a few years ago.
And what did you learn from his employment records?
He had been exposed to Drufo at a level very similar to the group that had the highest level of exposure in my study.
Okay, so based off of all your expertise as a toxicologist, all of the studies that you've conducted and read, what was the likely cause of Dakota Weirs' non-Hodgkin's lymphoma?
To a high degree of scientific probability, Dakota Weirs' non-Hodgkin's lymphoma was caused by his prolonged exposure to Drufo.
Thank you. Your Honor, I have no further questions at this time.
Ms. Caniglio, cross.
Yes, Your Honor. Dr. Rogers, I would first like to talk about the EU study that you brought up. Isn't it true that it is nowhere within your witness statement today that you found that study?
I did mention that Drufo had already been found to be carcinogenic in rats.
But isn't it true that you did not find that study and you did not state that within your witness statement?
I did mention that study.
But you did not mention finding that study, correct?
I'm not sure what you're asking.
Dr. Rogers, within your witness statement, you did not say that you found the study conducted by the EU, just that you knew of studies, correct?
I mentioned the study. It's implied that if I mention the study, I found the study.
Dr. Rogers, that is not what I'm asking you. I'm asking you if within your witness statement, you mentioned finding that study. It is a yes or no question.
I did not explicitly say the word find, no.
Thank you, Dr. Rogers. I would now like to talk about you specifically. Isn't it true that this is the first time you yourself have been called to testify in court as an expert?
My work has been used in litigation before.
Dr. Rogers, that is not the question I asked you.
Objection, cutting off the witness.
Hold on. If the witness isn't responding to a question, the appropriate way to instruct the witness is to direct that to the court's attention and ask the court to instruct the witness to respond. We're not going to banter back and forth with the witnesses over disagreements on whether they're responding to your question. I'll address those, and you address those to me, and I will address those to her.
Yes, Your Honor.
Your Honor, I asked my witness to be able to finish her answer to that question.
Well, I'm going to have her re-ask the question.
Yes, Your Honor.
Dr. Rogers, isn't it true that this is the first time you yourself have been called to testify as an expert in court?
My work has been used in litigation before, but if you're talking about being here in person, yes.
Now, Dr. Rogers, you're getting paid as an expert to be here, correct?
Yes, I am.
And you hope to be here in the future, testifying in court as an expert, correct?
I hope to make sure that companies like Lush Fertilizer aren't taking advantage of their customers, yes.
I heard a yes, Dr. Rogers. I would now like to talk about the study that you performed, and more specifically, the first part of it. Isn't it true that one of your groups contained people who were like farm laborers or gardeners?
Yes,
And your second group were casual gardeners and people like that, correct?
that's right.
Now, isn't it true that both of these people would have used numerous agriculture products, not just Lurch fertilizer?
Not in my study, no. The nature of Drufo is that it's an herbicide, a pesticide, and a fertilizer all in one. So people that use it don't generally use other fertilizers, pesticides, or herbicides.
Dr. Rogers, is it your testimony today that you know for a fact that the people in your study only used lush fertilizer?
Yes, I control for confounding variables in my experimental design.
So you monitored whether or not those other participants used other fertilizers?
Yes, I follow proper experimental protocol.
Dr. Rogers, isn't it true that that's not what you said in your witness statement?
I don't believe I specifically mentioned the procedures that I followed, but I didn't say anything to the contrary either.
So Dr. Rogers, within your witness statement, you did not see fit to state whether or not you only looked at Drufo within your study about whether or not Drufo was carcinogenic?
I'm sorry, could you restate the question?
Dr. Rogers, within your witness statement, when concerning your study in which you measured whether or not Drufo could be considered carcinogenic, you did not see fit to mention whether or not you monitored for other agriculture products?
Not in my witness statement. It's all contained in the report, as I do follow proper experimental protocol.
And Dr. Rogers, that report is not in court with us today, is it?
It's on the list of my publications. I believe it's publicly available.
But it is not in court today for the jury to see, is it?
If you did not bring it here, I guess it's not.
Now, Dr. Rogers, I would now like to move on to the second part of your study that you said was the results were inconclusive. Isn't it true that you had years to perform your study?
I did perform the study over about 5 years.
And Dr. Rogers, isn't it true that this study was done on your own? It was not done for a company?
Yes, that's correct.
So you did not have a deadline in which you needed to have this study done?
No, I did not.
And yet, Dr. Rogers, you did not take the necessary time to see whether or not these protective clothings could make any sort of harms be mitigated?
It was more important to get the study out as quickly as possible so that people like Dakota aren't put in this situation.
Dr. Rogers, you said it was a two-part study, so you could have published your findings for part one, correct?
That's not how that works.
Dr. Rogers, you could have done that all together and then conducted a different study to test those protective clothings, correct?
I'm not quite sure what you're asking.
Dr. Rogers, you could have published the findings of your study, correct?
I did publish the findings of my study.
And then you could have performed a second study to determine whether or not these protective measures could or could not impact these risks, correct?
I could have, yes. However, if I did choose to do so, the study would still be ongoing currently.
Thank you, Dr. Rogers. Now, Dr. Rogers, I would like to talk finally about the conclusions of your study, just overall. You could not control whether or not the Drufo was the only causal link between your participants and non-Hodgkin lymphoma, correct?
I believe we've already covered this, and yes, I did.
Dr. Rogers, based off of your witness statement and what you decided to put on it, you cannot make a full testimony in court today whether or not Drufo is the only causal link between non-Hodgkin lymphoma, correct?
I absolutely can.
Based off of what you put in your witness statement here today?
Yes, I can.
Dr. Rogers, isn't it true that you testified to not putting the procedures of your study in your witness statement?
I put all relevant information in my witness statement.
Dr. Rogers, you put all relevant pieces of your procedure in your witness statement?
Yes, I did.
Yet you testified that you did not put the procedures of your study in your witness statement.
I covered all of the necessary information as it relates to Dakota Weir's cancer and Drufo.
Your Honor, the witness is not answering the question I asked, as I asked whether or not she put the procedure in her witness statement as she testified to not having done earlier. Your Honor, you are muted.
Sorry. Dr. Rogers, if you could please respond directly to the question.
Yes, Your Honor.
Dr. Rogers, you testified earlier to not putting the procedure of your study within your statement, correct?
Yes, the exact procedure was not relevant.
Thank you, Your Honor. No further questions at this time.
Mr. Whitman, redirect.
Your Honor, before I decide if I'd like to redirect, may I inquire as to how much time I have remaining?
Excuse me?
Before I decide whether or not I would like to redirect, may I inquire as to how much time I have remaining?
Yes.
You have 16 minutes and 19 seconds remaining.
Briefly, Your Honor.
You can proceed.
You were asked a lot about what you did and didn't put in your witness statement. You didn't include the procedures of, or did you include the procedures of your study?
No, I did not. As I said, I followed proper experimental procedure, but if I'd included all of that information in my witness statement, it would have been pages and pages long, and no one is interested in all of that dry information. I just put all of the relevant information to Dakota Weir's cancer specifically.
And you were still able to come to an expert conclusion based off of your study, right?
Yes, I was. I also reviewed Dakota Weir's medical records and employment records.
Thank you. Your Honor, I have no further questions at this time.
Ms. Caniglio, any recross?
No request needed, Your Honor.
How would if the plaintiff would like to call their next witness?
Your Honor, I ask that Dr. Rogers be allowed to step down.
Oh, yes. Dr. Rogers, you're excused.
That, Your Honor, the plaintiff calls Carson Durst to the stand. Good afternoon, Ms. Durst. Could you please introduce yourself to the jury?
Hi, I'm Carson Durst. I work as a product developer at Terrace Greenery and have for about 15 years since I left Lush Fertilizer.
Now, Ms. Durst, I'd like to give a brief timeline of your experience for the jury. How did your career first begin?
After high school, I went to Arizona State University and graduated with a bachelor's in chemical engineering. At the time, I was actually super lucky, and my best friend's dad was the CEO of Lush Fertilizer, which helped me get an internship right out of college.
Tell us about that.
Honestly, when I was hired as an intern, I really thought I'd just be making coffee or running around the office as interns do. But instead, I was assigned to an entire flagship product, asked to research the effects it could have and research its components.
And what was this flagship product?
It was Drufo. That's really what Lush Fertilizer's success is dependent on. It's a binding agent, which essentially means it's sticky like glue.
And did you find any outside research of Drufo?
Yes, as an intern, I spent a while researching different components that made up Drufo and found one really concerning study in particular from England.
Ms. Durst, I'd like to direct your attention to Exhibit 3 on the stand.
Yes, I have it here.
Is that same study?
Yes, it is.
Your Honor, at this time, I ask that my trial technician be allowed to display Exhibit 3 as it's previously been admitted.
Fine.
Objection. Oh,
Is there an objection?
no, Your Honor.
Ms. Durst, why did you find this study concerning?
It was concerning for two main reasons, but first you have to understand a little background information. Now, this study was conducted by 4 separate scientists, as you can see here, about C3NO9P. That's just the fancy name for the compound that makes up most of Drufo now. Now, in the introductions column, you can see that it specifically concludes that this compound is carcinogenic, which basically just means that it causes cancer like lymphomas. But if you keep going to the conclusions section, it gets even worse. Because of these specific results that this study finds, it says that specific testing is needed to make sure that this substance is safe for children and women.
Thank you, trial technician, that can come down. So what did you do after finding this study?
Honestly, when I found the study, I wanted to shout it from the rooftops to Lush that we had like a really big problem. But that's just not how the company worked. Instead, we were told to write everything on our lab notebooks. Good, bad, insignificant. It might not sound like a problem, but now that I've worked for a different company, the real concern is with this method, there's no way to prioritize life-threatening findings like cancer for our customers.
And how did Lush Fertilizer react to you putting this study in your lab notebook?
I heard nothing. It was complete silence.
And what happened after this?
I was an intern at the time, so I really didn't know what to do. I had no experience, so I just kept trying to do my job as best as I could and hoping that Lush would later bring it up. I was promoted to a product development engineer after that.
And what happened next?
As a product development engineer, right at the beginning of my full-time employment, actually, Lush Fertilizer started a new study on Drufo.
And did this mean that Lush Fertilizer was taking the safety concerns of Drufo seriously?
Not at all. Actually, from what I saw, it was just the opposite. From our first study, Lush Fertilizer had already heard concerns that this substance, Drufo, was carcinogenic. But the second study was basically presented as they were trying to cover up those concerns.
Ms. Durst, I'd like to direct your attention to Exhibit 4 on the stand.
Yes, I have that here.
Could you tell the jury what this is?
This is the email that I received from my supervisor, sent to the whole Drufo team about this new study we'd be doing. It was sent on behalf of Lush Fertilizer on September 18th.
And is it fair and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 4 be admitted into evidence.
Ms. McDermott?
Your Honor, the defense objects on the grounds of hearsay.
Miss, I'm sorry. You don't have your names up there. It's hard to tell who this is.
Simpson, Your Honor.
Ms. Simpson. Okay, thank you, Ms. Simpson. If you'd like to respond?
Your Honor, this is not hearsay as it fits Rule 801 D2D, making this a statement of a party opponent. As this email was sent by an employee of Lush Fertilizer on behalf of Lush Fertilizer, this would make this a statement of Lush Fertilizer, the party opponent.
Ms. McDermott, any response?
I stand by my objection, Your Honor.
I don't think that the full foundation for this document has been laid yet, Ms. Simpson. So if it's not yet admitted, I don't believe the foundation's been laid yet.
Yeah. Now, Ms. Durst, who sent this email?
This email was sent from my supervisor, Gary Langley, at the time. He worked for Lush just like me.
And who is Gary Langley?
At the time, he was my supervisor, but really he's just a higher up at Lush Fertilizer.
Your Honor, at this time, I ask that Exhibit 4 be admitted into evidence.
Ms. McDermott?
Your Honor, the same objection, or Your Honor, no objections.
Exhibit 4 will be admitted?
May my trial technician publish to the jury, Your Honor?
Yes, they may.
Ms. Durst, what was the gist of this email?
Honestly, when I first received this email, I found it pretty bizarre. Like I was saying, the company had already heard conclusive results that Drufo was carcinogenic. But
Objection, Your Honor, hearsay.
Ms. Simpson?
Yes, Your Honor. This is not hearsay as it fits the same rule 801 D2 as Lush Fertilizer was receiving information that Drufo was carcinogenic from its employees, making this a statement of party opponent.
But it's not hearsay, so the objection is overruled.
Yes,
Yes, Your Honor.
Ms. Durst, did you get a chance to finish your answer?
no, not exactly. By this point, the company Lush Fertilizer had already heard concerns about Drufo being carcinogenic. but you can see in the second line right here, they don't deem them conclusive enough. Basically saying they'd be doing a new study to make sure that the results were right. But it went on even further. By the third paragraph, it basically told us that with this new study, if we found the same results, we were to bring them directly to management and not record them in our lab notebook, which completely went against Lush Fertilizer's protocol. They had always had us write down everything in our lab notebooks, so this basically implied to me that they didn't want a paper trail and didn't really care what the results were.
Thank you, trial technician. You can take that exhibit down. Now, what happened after this at Lush Fertilizer?
Honestly, I was really concerned that Lush didn't care about the results of the study. You have to understand, when you work for a company like that continuously puts profits over people, they basically go into these studies already knowing the results. But it was my job at the time, so I couldn't do much and went on to conduct the study, finding same concerning information.
And did Lush Fertilizer do anything to have you speak about your concerns?
Yes, after we conducted the second study, we all gathered in December of 2003 to share our concerns or just data in general to management. Now, my team specifically didn't find anything new other than the first concerns of carcinogenics from the England study, and that specific other tests need to be done not only for women, but also children. But a different group, one scientist specifically spoke up that worked at Lush Fertilizer to management that not only was this substance thought to be carcinogenic, but could now have a direct link to non-Hodgkin's lymphoma, which is a pretty serious cancer.
So just to be clear, this was the first scientist to find a connection between Drufo and non-Hodgkin's lymphoma?
No, not at all.
Objection, Your Honor, lack of foundation.
Sustained.
Ms. Durst, who spoke up in this meeting?
A scientist that worked at Lush Fertilizer spoke up about more concerns of this being directly tied to non-Hodgkin's lymphoma.
Now, Ms. Durst, was this the first scientist to bring up concerns of the matter?
To Lush, maybe, but in general, no. If you remember from the first study from England, there were 4 other separate scientists who found that this substance could be carcinogenic and directly tied to cancers like lymphoma. So actually, this was the 5th.
So despite hearing from 5 separate scientists that Drufo was connected to non-Hodgkin's lymphoma, did Lush Fertilizer do anything?
No, not at all. They didn't do any further testing like the England study called for, and all they really did was come out with a study report later on, but it was totally misleading.
And how is this misleading?
The study report came out and never even mentioned non-Hodgkin's lymphoma, which was a direct concern from the study, and even went on to represent baking the fertilizer as going above and beyond when we had never done any testing for that.
And finally, Ms. Durst, from your perceptions and observations being an employee of Lush Fertilizer, were they taking the health concerns of Drufo seriously?
No, not at all.
Objection, Your Honor, lack of foundation.
Ms. Simpson?
Yes, Your Honor. Ms. Durst has laid foundation that she, as an employee of Lush Fertilizer, knew the inner workings, that she knew how they reacted, and she would know if they were taking health concerns of Drufo seriously, as they had a recommendation to bake it but didn't, and other things. And she would know that being an employee of Lush Fertilizer.
Response, Your Honor.
Go ahead.
Your Honor, as the witness has testified to being simply an intern at Lush Fertilizer and has not testified to the complete inner workings of Lush Fertilizer and how she knows about the inner workings of Lush Fertilizer or what they think, the witness cannot testify to the fact that what Lush Fertilizer is doing to keep their fertilizer safe.
I think the objection is The objection is sustained to the extent that she's testifying to everything that the company does. If you want to rephrase your question, I think she's permitted to respond to the things that she knows about, but not in the general sense of what the company has done. So the objection is sustained.
Yes, Your Honor. And Ms. Durst, in your personal opinion, being an employee of Lush Fertilizer, were they taking health risks seriously?
Based on what I observed at the company as an employee, no, not at all. It didn't seem like they ever reviewed our lab notebooks because we got no follow-up on it. And even when they were told specific testing needed to be done to ensure this product was safe, they just brushed it under the rug, telling us to keep it under wraps when they didn't get the results they wanted.
Thank you. Your Honor, I have no further questions.
Ms. McDermott, cross.
Yes, Your Honor. Good afternoon. Good afternoon, Ms. Durst. You started out working off at Lush Fertilizer as an intern, correct?
Yes, and worked my way up to product development engineer.
Yes, and while you were an intern, your job was to research one of the chemical compounds in Drufo, isn't that correct?
I was on the research and development team, so that wasn't specifically my job to only research that one component, but it's what I spent most of my time doing.
Yes, and a part of this was researching the safety of that chemical compound, isn't that correct?
Yes, anything that could affect the product in general.
Yes, and during this time, you only found one study relating to the safety of Drufo, isn't that correct?
I found a lot of research, but yes, I found one very concerning study about safety.
And this study was conducted on rats, isn't that correct?
Yes, it was, which was why it was so important for Lush.
Thank you, Ms. Durst. I heard a yes.
Objection, Your Honor, cutting off my witness.
Okay. The witness needs to answer the question, and we're under a time constraint here today. The witness needs to answer the question directly. And again, if the witness is not responding directly, you need to address those concerns to the court. So.
Yes, Your Honor. Ms. Durst, would you like me to re-ask the question?
Yes, please.
And this one study that you found was done on rats, correct?
Yes, it was.
And you found no studies conducted on humans, isn't that also correct?
No, that's why follow-up studies by Lush were needed.
And you found this study in 2003?
Yes, the one as an intern, yes.
Yes. And 2003 was about 19 years ago?
Yes, that seems correct.
And you have found no subsequently completed studies since that 2003 study?
I really only worked at Lush Fertilizer for a few more years, so not really. That hasn't been my job for a while.
And Ms. Durst, in these 19 years, you have not seen fit to testify about your concerns, isn't that correct?
When I left Lush Fertilizer, I was made aware of a confidentiality agreement I had signed. So no, I wasn't able to bring up any concerns without being called to testify.
But Ms. Durst, you were called to testify, weren't you?
Yes, today, that's why I'm here.
Yes. And Ms. Durst, you thought that Lush Fertilizer is doing something wrong, correct?
Yes, that's why I tried to bring up concerns and follow company protocol.
Yes, but you didn't see fit to tell authorities about these concerns, isn't that correct?
Didn't really seem like they were doing anything illegal at the time. They were just covering up information, but I didn't have all the data.
And Ms. Durst, you left Lush Fertilizer in 2006, correct?
Yes, I did.
And so you are aware of nothing that has changed in the company since 2006?
No, I'm not. Looking at the product label today, it looks exactly the same.
Thank you, Ms. Durst. I heard a yes. Now, Ms. Durst, let's move on to talk about the email that you claimed to have received from Lush Fertilizer. You claimed to have received this email on September 18th, 2003, correct?
Yes, that's when it was sent. I either received it that day or the day after.
Yes, and you have not shared this information that was in this email before today, isn't that correct?
No.
And you are the only one here today testifying to the validity of that email. Isn't that also correct?
I'm not exactly sure if I understand your question.
Let me rephrase then. You are the only person here today that claims to have received this email. Isn't that correct?
On the email, it says that Blake Doncourt also got it, but she hasn't testified yet, so I guess I'm the first one.
Yes, and even though there are 17 other names on that list?
Yes.
Finally, Mr. Let's move on to talk about your time transitioning from Lush to Terra Greenery. You felt that your talents were being undervalued at Lush, didn't you?
Yes, it seemed that way.
And people accused you of just skating under the rug. Isn't that correct?
My performance reviews started to go down right around the time that I brought up concerns. Yeah.
So you decided that you would go talk to Blake Doncourt about it. Isn't that correct?
I tried to, but the first time I tried to bring up concerns, I was unsuccessful.
And Blake and Miss Doncourt told you to deal with it. Isn't that correct?
On the second meeting, yes.
And this made you mad, didn't it?
I wouldn't exactly say mad. I felt betrayed.
You were seething, weren't you?
No.
Ms. Durst, is it your testimony here today that you weren't seething?
Later on, yes, but not at the time. You might have mixed up the timeline a little.
And Ms. Durst, so you thought you saw the writing on the wall and decided to apply to Terrace Greenery. Isn't that correct?
I applied to a lot of fertilizer companies, as that's what I knew, and Terrace Greenery was one of the openings.
And Terrace Greenery is Lush's main competitor. Isn't that correct?
It's definitely one of the main competitors in the field.
And you thought that applying for Terrace Greenery would get Blake's scope, didn't you?
After I got the job, yeah.
And wouldn't you agree that Terrace Greenery would stand to benefit if one of Lush Fertilizer's products were to be found carcinogenic?
Yes, they could. Would you want to buy from a company that's known for causing cancer?
Thank you, Your Honor. No further questions.
Ms. Simpson, any redirect?
No redirect, Your Honor.
Thank you. The prosecutor, would the plaintiff like to call their next witness? Oh, you can be excused, Ms. Durst.
Yes, Your Honor. The plaintiff calls Dakota Weirs to the stand.
You can proceed.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Dakota Weirs. I'm here today because I have non-Hodgkin's lymphoma and I don't want anyone else to have to suffer like I have.
Have you ever worked with Lush Fertilizer?
Yes, I have.
When?
I used it when I was working for Haven Landscaping as a landscaping technician, basically spreading grass seed and fertilizer.
When did you work there?
I started when I was 14 and I ended around age 18.
Please look at Exhibit 1, which should be on the stand in front of you. What is this exhibit?
This is the photograph that my old boss from Haven Landscaping sent me of the Lush Fertilizer packaging.
Is it fair and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time I move to admit Exhibit 1 as evidence.
Ms. Wu, any objection? Okay. Exhibit 1 will be admitted.
Permission for my trial technician to publish Exhibit 1 via the chat and screen sharing features?
Yes, they may publish.
Mr. Weirs, using Exhibit 1, could you show us any warnings about cancer?
There are no warnings about cancer, just eye irritation and a couple safety recommendations.
What are those recommendations?
Well, it's the same thing that you see on every generic spray fertilizer. Use a mask gloves and long sleeves and pants.
Did anyone at Haven Landscaping follow those recommendations?
Although there were times where we were able to, there were times where me and my coworkers physically couldn't. We thought that we only risked eye irritation, and in our case, heat stroke if we wore proper protective equipment. So there were times where we really couldn't.
Thank you. Exhibit 1 is no longer needed. Mr. Weirs, if you had known of any possibility that Drufo could cause cancer, would you have worn the proper protective gear?
Objection, Your Honor. Speculation.
May I respond?
Yes.
Your Honor, this is not speculation pursuant to Rule 701, as this is rationally based upon the witness's perceptions and observations. I specifically asked Mr. Weirs about what his own actions would have been if he had known of the risk that Drufo could cause cancer.
The objection's overruled.
Mr. Weirs, were you able to answer the question?
Of course, I would have used protective equipment if I knew. I think any of us would have. Anything would have been better than this debilitating disease.
Based on what you've heard in court today, did Lush Fertilizer prioritize profit over people?
Absolutely.
Objection, Your Honor. Lack of personal knowledge.
Sustained.
Tell us about your life before the diagnosis.
Although being active in my community took up most of my time, my primary focus was always piano. I love playing piano, and it's really what I want to pursue as a career, and it's my passion.
Tell us about your future in piano.
Well, I started off when I was very young with my grandfather. He was a concert pianist, but I was offered a number of scholarships, but the one that I took was the one to Juilliard, or the one I would have taken, rather.
Could you even become a concert pianist anymore?
My condition, it's almost physically impossible. I can't sit at the bench long enough to play a song because it hurts too much. And of course, the hand tremors don't make it any easier. The shortness of breath just from sitting obviously will help that too.
Now, I'd like to talk about the type and extent of the non-economic damages you've suffered. First, how has your quality of life changed since your diagnosis?
Well, I never thought that I would go from the one helping out to needing all the help. Among that, I've lost all my independence, and my future entirely has become a hazy mess.
Are you in any physical pain?
Of course I am. Among the hand tremors, the bruising, everything, I also have swollen lymph nodes in my neck, which is why my voice might sound a little hoarse.
Have you experienced any inconvenience because of your cancer?
Of course, as I said, I've lost out on almost all of my independence. My life is just shattered.
What kind of emotional distress and trauma has this caused you?
My future at this point is unreadable, unclear, and everything is shattered at my fingertips. I can't even play in remembrance of my grandfather anymore. Do you know how painful that is?
Thank you, Mr. Weirs. Your Honor, I have no questions at this time.
Okay. Ms. Wu, cross?
Yes, Your Honor. Before I begin, may I request a time check?
Sure. Timekeeper can let her know.
Your Honor, there are 5 minutes and 33 seconds remaining.
Thank you. Go ahead, Ms. Wu.
Yes, Your Honor. Mr. Weirs, before I begin, I'd like to express our sympathies on behalf of the entire defense team for the situation you're in.
Thank you.
Now, isn't it true you worked at Haven Landscaping for 4 years?
Yes.
You were responsible for spreading seed and fertilizer?
Yes, those were the primary focuses of my job.
And over the course of your time with Haven, you used several different types of fertilizer, correct?
Yes, I did use a couple different fertilizer, Lush fertilizer being the main one.
Right, several different types of lawn chemicals.
Yes, long chemicals are fertilizers.
Let's talk about the instructions your boss told you to take then. Your boss instructed you to always cover your face when using fertilizers, correct?
We were always advised to.
But you didn't follow that, did you?
There were times where I could not. Physically, as I said on direct, we risk getting heat stroke.
Right. Your boss told you to always wear long sleeves, correct?
Yes.
But you didn't follow that, did you?
Again, there were times where me and my coworkers physically couldn't.
Your boss told you to always wear pants, correct?
Yes.
And you didn't follow that, did you?
There were times, yes.
Your boss told you to always wear gloves.
Yes.
And you didn't follow that, did you?
There were times where me nor my coworkers did.
Yet you were told to always take these, correct?
Yes, they were never particularly enforced by the packaging or by Haven.
Right, and the reason why you didn't follow these is because it was too hot, correct?
That's one of the biggest reasons, yes.
Now let's take a look at Lush Fertilizer's label. You said earlier that you had your boss at Haven send you a copy of the Lush label, correct?
Yes.
Your Honor, permission for co-counsel to screen share what has been previously entered as Exhibit 1.
That's fine. Go ahead.
Now, do you see the word hazards at the top?
Yes, I do.
And it's followed by keep out of reach of children, correct?
Yes, it is.
Do you see the words caution?
Yes.
And it's followed by causes eye irritation, correct?
Yes, this is the only warning on there.
Right, now let's direct your attention to the bottom right. Do you see the words user safety recommendations?
Yes, I do.
These instruct the user to wear protective clothing as with any spray fertilizer, correct?
That is correct.
Yet you didn't follow these explicit user safety recommendations, did you?
No, seeing as they weren't listed under warnings or hazards, we took them as they were, recommendations.
Right. These were the same recommendations your boss told you to always follow, isn't that true?
Yes, with the caution being eye irritation, not non-Hodgkin's lymphoma.
I understand that, Mr. Weirs, but these are the same recommendations your boss told you to always follow, correct?
Objection, Your Honor. This is needlessly cumulative pursuant to Rule 403. Opposing counsel has already questioned repeatedly.
Overruled.
Mr. Weirs, could you please answer the question?
I'm very sorry, can you repeat it?
Yes, these are the same recommendations that your boss told you to always follow, yes or no?
Yes, me and my coworkers.
Your Honor, co-counsel may stop screen sharing. Now let's talk about the fertilizers, the other fertilizers that you used. You were exposed to numerous fertilizers, correct?
Yes, I used a couple other fertilizers at Haven Landscaping.
And these fertilizers, they came with their own safety precautions, didn't they?
Most of them did, yes.
One instructed that an eye covering was necessary.
That's correct.
One instructed that a mask covering was necessary.
Yes, as most fertilizers were worn.
Yet you didn't follow those instructions, did you?
Most of the time I tried my hardest to. There were times where I couldn't though.
And other products instructed you to use their product outdoors, correct?
That's correct.
But you used their products indoors, didn't you?
There were some occasions where we were instructed to, but I mainly used Lush fertilizer indoors, not those other chemicals.
Yet these labels on these fertilizers, they never changed, did they?
No, they did not.
So you didn't follow the instructions your boss told you to take, correct?
We were all recommended to.
But you didn't follow those instructions, did you?
There were times where we couldn't.
You didn't follow the instructions on the Lush label, correct?
Again, there were times where we couldn't.
And you didn't follow the instructions on these other fertilizers, correct?
Most of the time on the other fertilizers, I was able to.
But you didn't always follow those, yes or no?
No one always followed those.
And so even though you're exposed to all these other fertilizers, you have no idea what is in those other fertilizers, yes or no?
I'm sorry, counsel, can you rephrase that question?
Yes, Your Honor. Yes, you have no idea what is in these other fertilizers you were exposed to, yes or no?
Although I don't have the verbatim ingredients, I have a pretty good idea.
But you have no idea what exact ingredients are in these other fertilizers, yes or no?
Not the exact percentages.
Thank you. No further questions, Your Honor.
I don't know if there's any time remaining for redirect. Ms. Feeney?
May I inquire as to how much time I have remaining?
Yes, you may.
You have 8 seconds remaining.
Very briefly, Your Honor.
Okay. You can proceed.
Could you always wear protective gear?
No, it was not possible.
Thank you. No further questions.
Ms. Wu, I don't know if you have time for recross, but.
No recross necessary, Your Honor.
Okay, thank you. Anything further from the plaintiff?
No, Your Honor. The plaintiff rests.
How would the defense like to proceed?
Your Honor, before the defense proceeds, we would just like to confirm that exhibits 1, 3, 4, 6, and 7 have been entered into evidence.
Yes, those have been.
Your Honor, may Mr. Weirs be allowed to step down from the stand?
Yes, I'm sorry. Mr. Weirs, you can step down from the stand. I'm not used to having people actually on the stand in this virtual form. Thank you for your time. How would the defense like to proceed, Ms. Wu?
Your Honor, the defense calls Blake Doncourt to the stand. Your Honor, for clarity's sake, would it be possible for opposing counsel to turn off their witness camera?
Yeah. Yes.
Your Honor.
I was just going to suggest that.
Thank you.
Okay. You can go ahead, Ms. Wu.
Yes, Your Honor. Good afternoon, Ms. Doncourt.
Good afternoon.
Would you please introduce yourself to the jury?
Hello, my name is Blake Doncourt. I am the CEO and founder of Lush Fertilizer.
What is Lush Fertilizer?
At Lush, we develop and produce yard and commercial fertilizers while also aiming to mitigate the common negative effects associated with agricultural products.
Why was the company founded?
Well, ever since I was little, I've loved the environment. So when I got older and I started seeing the state of the climate, oceans being polluted, coral reefs bleaching, wildfires, I wanted to find a way to make the world a greener and healthier place.
How so?
Well, it started with my product at Lush. However, we also go further with donating to charities, which are helping to decrease the nitrogen footprint.
Objection, Your Honor. Any mention of environmental charities or environmental work is not relevant pursuant to Rule 401 and substantially more prejudicial than probative pursuant to Rule 403.
Ms. Wu?
Your Honor, in regards to the more prejudicial than probative, Your Honor, this does not be more prejudicial than probative as the probative value substantially outweighs the prejudicial effect.
What's the probative value?
Your Honor, the probative value and why the witness is saying this is relevant is because what the company does in their community goes to what they do in good or bad faith with their chemicals. It goes to how Lush treats their chemicals. And the plaintiff was allowed to talk about herself, and we ask that you extend the same courtesy to talk about why the company was founded.
May I respond?
Go ahead.
Your Honor, in that case, I also raise a 404A objection as this evidence is being used to show that Lush Fertilizer Incorporated has a character trait for generosity and community work, which to show that they acted in accordance when regarding the testing for safety of Drufo.
Objections overruled. You can proceed.
Ms. Doncourt, please continue.
Right, so we also have our own charity, which is helping to clean up the most polluted parts of the ocean. And one of my favorite things that we do is work with state and national legislature to implement education on the climate situation worldwide.
Has your company been recognized for these efforts?
Yes, we've been honored to have been awarded the SEAL Business Sustainability Award. And I was also personally recognized by the UN Champions of the Earth Award in 2020.
Why are you here today?
I am here to show that my company has never and would never do anything to others at risk.
Now let's talk about your fertilizer a little bit. Is your fertilizer different than other fertilizers?
Yes, it contains a revolutionary compound which makes the fertilizer safer than any other on the market.
What is that fertilizer?
Objection, Your Honor. The statement that Lush fertilizer is safer than any other fertilizer on the market requires expertise pursuant to Rule 702, which Ms. Doncourt does not have, making this improper lay witness testimony pursuant to Rule 701.
Wu?
Your Honor, this would not be an improper lay opinion, as Ms. Doncourt would have personal knowledge to how her fertilizers compare with other fertilizers on the market, as she is the CEO of one of the leading fertilizer producers.
I think the objection is sustained. I don't think you've established a foundation for knowing, for being able to issue that opinion. So,
I move to strike the statement that Lush is safer than all other fertilizers.
the jury will disregard the statement that Lush is safer than all other fertilizers.
Let's continue, Ms. Doncourt. What is that compound you're referring to?
That compound would be Drufo, which acts as a bonding agent in our fertilizer.
What does Drufo do?
So Drufo, as a bonding agent, when it's applied with the fertilizer onto the grass and onto plants, it sticks onto these plants and grass, and therefore it decreases the amount of runoff when water or rain comes along.
Why is that important?
Well, when chemicals do run off from the grass and the plants, it can get into the soil, into the water, and therefore into the people. So by decreasing this, we decrease the negative effects for both the environment and for the people.
Objection, Your Honor. I re-raise my previous objection that this requires expertise, specifically in agriculture or toxicology.
Overruled.
So how long did it take to develop Drufo?
It took years and working day and night with a significant amount of capital. It really, development lasted for about 3 years. However, we continue to run studies to further refine our product.
So let's talk about those studies. What did you learn from these studies?
So from those studies that our toxicology research development performed, we learned that from all the conclusions, Drufo is, when in our fertilizer, significantly increases the safety of that fertilizer.
What else did you learn?
Well, in the reports that we get back from that team, they often add some additional information. And in one of these reports, they added a process which would include baking our fertilizer.
Let's talk about baking a little bit. What is that treatment?
Baking would mean that we would, bake our fertilizer, and that would decrease the carcinogenic risks.
Does Lush bake their products?
After receiving all the studies and research from our toxicology research and development team, we found no significant risk of any carcinogenic effects. So therefore, after looking into the process, we found it unnecessary and decided not to do so.
Now, let's talk about the label on Lush fertilizer as it relates to customer safety. Do you address customer safety on the fertilizer?
Absolutely. As all fertilizing companies should, we make sure to put a safety precautions on our label.
Is there a label for specific risks because of Drufo?
According to state and federal guidelines, there is no need to put any type of warning because of Drufo on our label, as it was found to be safe. Furthermore, it goes with EPA, what the EPA has approved for our label.
Let's talk about this label now. Your Honor, permission for co-counsel to screen share what has been previously entered as Exhibit 1.
Okay, go ahead.
Ms. Doncourt, are there recommendations on this label?
Yes, again, as all fertilizing companies do, we have safety recommendations for the user's safety.
Did you hear Mr. Weirs testify in court today?
Yes, I did.
Based on what you heard, did Mr. Weirs follow your label?
From what I heard, by not covering up their skin with long sleeves and long pants, by not wearing an N95 mask, he did not follow any of the safety precautions on our label. Furthermore, as a minor, it goes against our label, which says keep out of reach of children.
Thank you. Co-counsel may take down the screen sharing now. Let's talk about what else we heard today from Mr. Weirs. What did you hear from Mr. Weirs today about other fertilizers?
I heard that he used many, and of these many, we don't know how many or what they actually were. So we have no way to trace the actual chemicals and potential risks in these other products.
Let's talk about risks a little bit. What risks are you able to control?
The risks I'm able to control are within my own product, which we control throughout studies and research and looking at the science and the data, which all pointed to a safe product.
What risks are you unable to control?
I'm unable to control whether or not those who use the fertilizer put on the safety gear that they are instructed to in order to protect themselves. Furthermore, we cannot control the risks of other chemicals and other products.
Now let's talk about the claims Ms. Durst is making today. About these claims, has Ms. Durst ever made these claims known to you?
Not once while working at our company. In fact, she only brought these claims up after she left our company and going over to a rival company and being in this trial.
Did she make these known to you while she was working at Lush?
No, which is against her actual role at our job as a research and development member of the team. It was her job to report to myself and her upper management.
Did she sign any business documents with you?
Yes, she signed a non-compete agreement when she was being hired onto Lush.
Did she follow this?
Unfortunately, no. She specifically went against that non-compete agreement.
Now let's talk about what has been previously entered as Exhibit 4. Have you ever seen this email before?
No, in fact, it is Lush's official position that this email was manufactured. We turned over our entire email system to the plaintiff's lawyers, and they looked through the entire thing and found no trace of this email or any email similar to this.
Now, you mentioned studies earlier. How did the studies you review compare with Ms. Durst's claims?
The studies that I received and the reports all showed no causal link between non-Hodgkin lymphoma and Drufo, or any sort of cancerous risk. In fact, all of our researchers came to opposite conclusions that Ms. Durst is claiming today.
Finally, Ms. Donkart, you've mentioned safety quite a few times today. How can you guarantee the safety of your fertilizer?
By looking at the hard science and data, which all pointed to a safe product. And I am proud to have been a part of Drufo's development.
Thank you. No further questions at this time, Your Honor.
Ms. Feeney, cross.
Yes, Your Honor.
Ms. Feeney, if you want, you can do cross from the table, but it's up to you.
Your Honor, I will conduct cross-examination from the well if that's all right, so that the jury may see me better.
That's fine.
Ms. Doncourt, you talked a lot about the safety of your product on direct, but just to be clear, you do not have any degree in toxicology, do you?
I do not. However, that is why I employ those who are educated and have specific degrees.
But you never conducted any research, did you?
I got reports back, which thoroughly went through the studies and the processes. However, I myself only oversaw the research and development.
So that's a no to my question. You never conducted any research.
Not myself, no.
Now let's talk about your product. Lush fertilizer is designed to create vibrant green grass, right?
That is correct.
And it can be purchased by anyone, can't it?
It is largely purchased by governments, large businesses, and individuals. However, it also says not for any use of children.
However, anyone can purchase Lush fertilizer, yes or no?
That is correct. It is on the market.
Your product contains Drufo, doesn't it?
It does.
Which is a binding agent, correct?
An effective one at that, yes.
Meaning that Drufo glues the fertilizer to what it's sprayed on, right?
That is correct.
We can agree that if there are any risks associated with the use of your product, that there should be warning labels, correct?
Of course. However, since no studies found any, there was no need for any sort of warning label.
But if there were risks, there should be warning labels, yes or no?
Correct.
If Drufo was found to be carcinogenic, it shouldn't even be on the market, should it?
It would never, and I would never, as a CEO, put any sort of harmful product on the market.
We can agree that if your company put a dangerous product in the hands of the public, there would probably be a paper trail, wouldn't there?
There would, however, as I said, our email systems were turned over to the entire plaintiff's lawyers, and they found no sort of paper trail.
Well, let's talk about that paper trail. It was Carson Durst's job to look for any risks associated with Drufo, right?
As a part of the toxicology research and development team, that was her job.
Permission for my trial technician to display Exhibit 3 on the screen, which has previously been admitted.
That's fine.
Ms. Doncourt, this is the study that Carson Durst found, correct?
That is what I heard in court today, yes.
And while not by name, this study mentions your company using Drufo in its products as a binding agent, right?
It looks into a part of the compound of Drufo. I do not believe it says anything about Lush specifically. However, I do believe it's referring to Drufo.
This study found a dose-related increase in lymphomas and leukemias from use of C3N09P. Yes or no?
In rats, that's what it says in the study, yes.
The study also calls for follow-up testing to be done on humans, correct?
I've never specifically seen this document, so I cannot specify where on the screen it is.
If you look in the conclusions section, as my trial technician is highlighting, it does call for further testing, yes or no?
It does, yes.
Thank you. The exhibit is no longer necessary. Now let's talk about baking. Baking your fertilizer would have removed any risk that it could cause cancer, yes or no?
Yes, however, the product was already found to not cause cancer, so we found no need to do so.
Your own internal study recommended baking Drufo, isn't that right?
It was not recommended, it was just added as some extra information.
However, it did recommend that if there was risk that Drufo could be carcinogenic, that it should be baked, yes or no?
That is not specifically in my statement, and it was only added as extra information, never as a recommendation.
Regardless, you chose not to bake your fertilizer, isn't that right?
Because it was unnecessary, yes.
However, there was still a little bit of risk that Drufo could cause cancer, wasn't there?
There is risks in all agricultural products. However, ours has a substantially less amount of risk in Drufo.
That wasn't my question. Drufo does still carry some risk that it could cause cancer, yes or no?
Very little, yes.
You chose not to bake your fertilizer because it would have been too expensive, right?
That was only part of the reason. It would be too expensive because it's an unnecessary process.
But that is a yes to my question. The cost of baking your fertilizer was one of the reasons you chose not to do so.
It stemmed from it being unnecessary, but I suppose so, yes.
In making this decision, you created an amortization table, correct?
That is.
This table looks at your projected profits from 2004 to 2014, right?
That is correct. When I was making it, it was early in our development. So it was only speculation for our growth and profits going further.
Please refer to Exhibit 8, which should be in front of you. Do you have that exhibit?
I do once I pull it up.
Do you have Exhibit 8 in front of you, Ms. Doncourt?
1 second, I'm going through all the exhibits. There's quite a bit. Yes, I did.
Your Honor, if you would like, I can also screen share Exhibit 8.
That would be helpful, actually.
That's fine. Hold on. Ms. Feeney, do you want It's her witness. I'm going to allow her. Do you want it screen shared?
Yes, Your Honor. If necessary, my trial technician can display Exhibit 8 on the screen.
Okay. Well, hold on. I don't know who has it up.
I'm the plaintiff's trial technician, Your Honor.
Okay, that's fine. Okay, thank you. Go ahead.
This is the amortization table you created, correct?
That is correct.
It's fair and accurate?
That is a fair and accurate copy, yes.
Your Honor, at this time, I move to admit Exhibit 8 into evidence.
Ms. Wu, any objection?
No objection, Your Honor.
Exhibit 8 will be admitted.
May my trial technician publish to the jury via the chat function?
That's fine.
Ms. Doncourt, in 2004, it would have cost $250,000 to bake Drufo, correct?
That is correct.
And in that same year, your profit was $1,675,000, wasn't it?
That was the projected profit, yes.
And your profit was projected to grow by 6% in the first year and 2% every year after, correct?
That is correct, yes.
Thank you, Your Honor. I have no further questions. However, I do at this time ask the court to take judicial notice pursuant to Rule 201 that the total profit from 2004 to 2014 would be $18,994,341. This number is the result of adding all of the numbers in the column titled Profit Before Baking.
Well, I'd have to do the math on that. Ms. Wu, any objection?
No objection, Your Honor.
Okay. The court will take judicial notice of the $18 million total profit. Ms. Wu, any redirect?
Yes, Your Honor, briefly. Ms. Doncourt, is customer safety a priority for you?
Absolutely. The safety of those who use a product is the first thing we consider throughout every step of development, and safety was never sacrificed throughout any of it.
Thank you. No further questions, Your Honor.
Ms. Feeney, any recross?
No, Your Honor.
Okay. Ms. McDermott? Would you like to call your, Ms. Doncourt, you're excused.
Thank you, Your Honor.
Ms. McDermott, would you like to call your next witness? Oh, I'm sorry, is it not McDermott? It's Ms. Caniglio. I apologize.
Yes, Your Honor. The defense would like to call Skylar Race to the stand.
Okay. You can
Good
proceed.
afternoon. Thank you, Your Honor.
Good afternoon.
Would you please introduce yourself to the jury?
Hello, my name is Skylar Weirs, and I am an investigative journalist for the Rationalist magazine.
Do you recognize anybody here today?
I do, yes. I recognize my twin brother, Dakota.
Why are you testifying against your twin?
I'd honestly rather not be testifying against Dakota, but I have to do what is right, and that is tell the truth.
And what is the truth?
Well, I'm here today to tell the truth about my research, which shows that there is no causal link between cancer and Drufo.
Now let's talk a little bit about you. Would you please remind the jury your current occupation?
Yes, I am an investigative journalist.
And during your time as an investigative journalist, have you ever been published?
I have, yes, numerous different times.
What have you had published that's relevant to this case?
Well, I have had actually several different articles on the conflict between corporate policy and individual health published, as well as a series of articles on modern agritech.
Let's talk a little bit about that series. What did you research for it?
I researched many different things, but one of the main things was different publications from various different agritech companies.
What did you do with those publications?
Well, I went through them and I looked at every single study they had mentioned and went through all of those and reviewed them.
Was that all you reviewed?
No, I actually looked at a wealth of information from government databases.
Which ones?
I looked at information from the United States Department of Agriculture, as well as the National Association of State Departments of Agriculture.
And how long did this process take?
The process took me nearly an entire year, which is a long time compared to my other articles.
And during your research, did your knowledge within the field of modern agritech grow?
Yes, substantially.
Your Honor, the defense moves to enter Skylar Weers as an expert in modern agritech pursuant to Rule 702 under experience, knowledge, and skill, as well as pursuant to the pretrial motions under which Judge Stab ruled that if the defense could prove that Ms. Weers looked at agritech companies and their publications, the studies within those publications, and information from the United States Department of Agriculture, the National Association of States Department of Agriculture, she would have more knowledge than the average juror in this case and would be allowed to testify as an expert.
Mr. Winton?
Your Honor, I object in the same grounds that on my pretrial motion, that the witness is not qualified under Rule 702 as simply reading secondhand research provided by other qualified experts does not qualify somebody to testify and render opinions as an expert in the field of agritech.
Thank you, Mr. Winton. Given the pretrial ruling on this issue, I find that the facts have been established as required by the pretrial order, and Ms. Weers will be admitted to testify as an expert in modern agritech.
Yes, Your Honor.
Yes, Your Honor. Let's talk a little bit about your research. What did your research focus on?
Well, it focused on a variety of different things, but one of my main focuses was the safety of different fertilizers.
Did you research lush fertilizers part of your series?
I did, yes. It was one of the many different fertilizers I looked at.
And did you look at other fertilizers as well?
Yes, I did.
And what did you find about their safety?
Well, the conclusion I came to was that no fertilizer will be 100% safe. However, some fertilizers are safer than others.
And what fertilizers are safer than others that are relevant to this case?
Well, lush fertilizer is actually safer than other fertilizers because of its use of DRUFO.
Based on your research, how does DRUFO make lush safer?
Well, you see, DRUFO is an effective bonding agent and pesticide, and it essentially works by bonding the grass to the other chemicals used within lush fertilizer, and it essentially just acts as a superglue.
Why is that significant?
Well, it's significant because all of these other chemicals within lush fertilizer aren't released into the environment nearly as often as other fertilizers. Additionally, lush fertilizer doesn't have to be applied as often as other fertilizers. So it makes it so that this exposure to these harmful chemicals is way less than other fertilizers.
Now, you mentioned that lush is safer than other fertilizers. Is DRUFO the only reason?
No, it is not actually.
What are some of the other reasons?
Well, you see, nitrogen is the only substantially harmful chemical used within lush fertilizer. And the nitrogen exposure is lessened because of DRUFO. And that's contrasted to other fertilizers that actually have known carcinogens like glyphosate and arsenic within their fertilizer.
Based on your research, do other fertilizers use nitrogen?
Yes, they do.
And is the nitrogen that they use different than the nitrogen lush fertilizer uses?
No, it's actually all relatively new information, but most modern fertilizer companies use synthetic nitrogen, which is actually substantially harmful for the environment.
Why is that?
Well, like I said, it's new information, but synthetic nitrogen can affect waterways and it can go into drinking water and crops.
This is improper expert testimony pursuant to Rule 702 as talking about the environmental impact of these fertilizers is outside of the witness's expertise.
Niglio?
Your Honor, the witness has been entered as an expert in modern agritech and is simply talking about how her research within that field showed the way that these new technologies within agriculture affects the world around them.
Objections overruled.
Yes, Your Honor.
So this synthetic nitrogen can go into drinking water and it can go into irrigating crops, which eventually leads into getting into people, which can be harmful.
Let's talk a little bit more about your relationship with your twin. How has your twins' diagnosis affected you?
Well, it's been really hard on me. I mean, Dakota is my twin brother, and all I want to do is to support him. So I actually did that by looking further into Truffaut.
You said you looked further. Did your research into Truffaut start before the diagnosis?
Yes, it actually had started before, but when he was diagnosed and he thought it had something to do with Truffaut, I wanted to find that causal link for him because he was relying on speculation and I wanted him to get closure. But my research found that there is no causal link.
Ms. Weirs, why are you testifying for the defense in this case?
I am testifying because it is my job as an investigative journalist to put the scientific information out there. My job does not rely on speculation. It is only about science. And that science is why I'm here today.
And Ms. Weirs, based off of all of your research and your expert opinion in this case, what is that science?
In my expert opinion, I found that there is no causal link between Truffaut and cancer.
Thank you, Your Honor. No further questions at this time.
Mr. Winton, cross.
Yes, Your Honor.
You can proceed.
We can agree that pesticides are by definition poisons, right?
That is a fact, yes.
And Truffaut is an effective pesticide, right?
Yes, it is.
Now, I want to talk a little bit about some problems that you've had with honesty. You had to lie about your age to gamble in high school. Am I correct?
Objection, Your Honor. Relevance?
Mr. Winton?
Your Honor, this is relevant as it is proper cross-examination as to the quality and credibility of this witness. This witness lying about her age in order to take place in what was then for her an illegal activity goes directly to the credibility and to the weight the jury should give her testimony.
Objections overruled.
So you had to lie about your age to gamble in high school.
Well, I wouldn't necessarily say lie. I mean, a lot of people around me, flubbed their age because they wanted to participate in things like, fantasy football and everything, just like I did.
So you were gambling in high school.
Unfortunately, I did make that decision.
And this decision put you into quite a bit of debt, didn't it?
I wouldn't say quite a bit, but it is as much as I have to pay it back, so.
Well, you're still in debt to this day, aren't you?
Objection, Your Honor. Relevance?
Your Honor, this is relevant as it is proper cross-examination as to the quality, credibility of this witness. This witness being in debt goes directly to the fact that her journalism career, which is my next few questions, is not particularly lucrative because she is possibly not an excellent journalist.
Response, Your Honor?
Go ahead.
Your Honor, whether or not the witness has been put in financial debt because of her gambling choices does not go to the credibility that she has as a journalist, nor does it show any relevant that would make any fact in this case more or less probable as to the potential carcinic qualities of Truffaut, which is why we are here today.
Okay. The objection is sustained. I just don't think you've laid the foundation for this line of questioning yet, Mr. Winton.
Yes, Your Honor. You can't make ends meet with your journalism career alone, can you?
Unfortunately, my passion as an investigative journalist doesn't exactly allow me to pay all of my bills and pay off my gambling debt.
Meaning that you have to work as a part-time server at Applebee's, right?
The perfect job, actually, because it allows me ample time to focus on my research.
That's a yes to my question.
Oh, yes.
So I want to talk a little bit about the reaction that you claim towards Lush Fertilizer. You would describe our allegations against Lush Fertilizer as mass hysteria, wouldn't you?
No, I would not.
Have you ever said that the allegations against Lush Fertilizer amounts to nothing more than mass hysteria?
From the media, but not particularly from the plaintiff in this case.
But the reaction against them is mass hysteria, right?
Part of it is, yes.
So I want to talk a little bit about what your research found. Nitrogen is known to cause many adverse health effects, isn't it?
Unfortunately, it is, yes.
And I'd like to direct your attention to Exhibit 1, specifically the second active ingredient. That ingredient is nitrogen, right?
Well, you see, like I said, nitrogen is the only substantially harmful one in lush fertilizer, and it's actually, the exposure is mitigated because of DRUFO. But yes, it is the second ingredient on that list.
Okay, let's talk about that for a second. 51% of lush fertilizer is just other ingredients, right?
Yes, I believe so.
And meaning you don't know what's in there, do you?
Well, I don't know the specifics exactly, but I know that nitrogen is part of that.
Meaning you can't say that nitrogen is the only toxic ingredient, can you? Because you just don't
Well,
know.
all of my research has showed that nitrogen is the only substantially harmful chemical within lush fertilizer.
Now, the research on DRUFO and it being carcinogenic is inconclusive, right?
Which means that there is no conclusive causal link, yes.
Right, meaning you cannot sit there and say that it definitely doesn't cause cancer, can you?
I can say that because all of the research has shown that there is no causal link.
So you can draw conclusions from inconclusive research?
It's exactly what it says. If it's inconclusive, that means that it doesn't show a carcinogenic quality.
So it's a yes to my question.
Can you restate your question so I can make sure it's a yes?
You're claiming that you can draw a conclusion from inconclusive research.
Yes.
Finally, we can agree that lush fertilizer isn't safe, is it?
No, of course not. Yes, sorry. Lush is never going to be 100% safe, just like all other fertilizers.
Thank you, Your Honor. No further questions at this time.
Ms. Caniglio, any redirect?
Yes, Your Honor. Briefly. Ms. Weirs, has your gambling impacted your journalism?
Of course not. My journalism is actually just the same as it was before I had gambling debt.
Now on cross, counsel asked you a bunch of questions about the safety of Lush and nitrogen within it. Is Lush safer than other fertilizers?
Yes, it is.
And is the nitrogen they use different?
No, it is not.
And is there anything about this nitrogen that makes Lush safer?
Yes, the nitrogen exposure is actually limited because of DRUFO.
Thank you, Your Honor. No further questions.
Mr. Winton, any recross?
No recross, Your Honor.
Yes. Now, Ms. McDermott. Oh, you're excused from the witness stand, Ms. Weirs. Ms. McDermott, how would you like to proceed?
Your Honor, the defense calls for Dr. Devin Williams to come to the stand.
Dr. Williams?
Your Honor, before I begin, may I request a brief time check?
Sure. If you could let her know.
Your Honor, there are 8 minutes and 49 seconds remaining.
Thank you. You can proceed, Ms. McDermott.
Yes, Your Honor. Good afternoon, Dr. Williams. Could you please introduce yourself to the jury?
Good afternoon. My name is Dr. Devin Williams, and I'm the lead of Lush's research and development team.
And why are you here today, Dr. Williams?
I'm here today because I've conducted years of scientific studies that prove DRUFO's safety.
Dr. Williams, let's talk about some of your professional qualifications as a scientist. Let's start off with your education. Do you have any degrees?
Yes, I do. I have many. I have a bachelor's in science specializing in toxicology, and I have a master's in science specializing in forensic toxicology. I also have a PhD in toxicology and pharmacology.
Anything else?
After I graduated, I did a post-PhD program at the University of Utah to further deepen my knowledge of toxicology and pharmacology.
Dr. Williams, have you spent any time as an educator?
I have. For 7 years, I taught as a professor at Colorado State University as a professor in toxicology and medicinal chemistry. I especially love teaching my students all about the small intricacies of medicinal chemistry, and all the small little aspects about it was a really special time.
Dr. Williams, you previously testified to working at Lush Fertilizer. Did you conduct any studies with Lush?
Yes, over years I've conducted numerous scientific studies at Lush Fertilizer, and each time that I start a new study, I gain back an old memory of participating in middle school STEM fairs and gaining a few blue ribbons from that.
And finally, Dr. Williams, about how long have you been working in the field of toxicology?
I've been working with my degree since 1993, or 28 years. That's almost all of my professional life.
Your Honor, pursuant to Rule 702, the defense moves to enter Dr. Devin Williams as an expert in pharmacotoxicology and medicinal chemistry due to his education, training, and experience.
Ms. Simpson?
Your Honor, as Colorado has an extremely low bar for who can be an expert, I have no objection.
Dr. Williams will be admitted as an expert in pharmacology, medical pharmacology, and I can't recall the other one you listed, but in the areas that you listed, Ms. McDermott.
Yes, Your Honor. Dr. Williams, how long have you spent working for Lush Fertilizer?
I've worked at Lush Fertilizer for about 10 years, and I've been the head of a research and department team for 7 of those.
And what type of work do you do for Lush?
My team and I examine the safety of our various chemicals, and we ensure that we're both safe for our consumers and for the environment.
What product have you been focusing on specifically?
In recent years, I focused on the chemical Drufo.
What is Drufo?
Drufo is the revolutionary product of Lush Fertilizer and the flagship product of Lush, and it is changing the fertilizer industry with its revolutionary developments.
Dr. Williams, to your knowledge, how is Drufo different from other fertilizer products on the market?
Drufo is a bonding agent, meaning that it sticks to the plants that it's applied to. It's like a few witnesses before me mentioned, it's like super glue. This means that less fertilizer needs to be applied because more fertilizer sticks onto the plant.
How does this contribute to it being revolutionary?
The fact that less fertilizer needs to be used means that toxins from other companies' fertilizers go into the soil, go into the water, and go into you, the people, less.
Dr. Williams, during your time with Lush, have Lush Fertilizer conducted any studies?
Over the last 20 years, Lush Fertilizer has run countless scientific studies on Lush and Drufo throughout every single stage of its development.
And how do you conduct these scientific studies?
My team and I examined the various safety risks and concerns, or lack thereof, of our products as compared to the products of other companies.
And did you gain any data from these studies?
Yes, we gained a plethora of data from these studies.
And what did the compilation of this data tell you?
In my expert opinion, the data from these studies pointed directly to one conclusion, and that conclusion is that there is no statistical correlation between Drufo and non-Hodgkin lymphoma.
What exactly does that mean?
This means that there is no increased likelihood of getting non-Hodgkin lymphoma between somebody who has used our product on a daily basis versus somebody who has never used it at all.
Dr. Williams, we've talked about how Drufo is used. Now let's talk about where it's used. Is Lush Fertilizer, or more specifically Drufo, used in the United States?
It's the best fertilizer on the shelf. Go to your store, buy it, and make your grass beautiful and green.
Is it used anywhere else in the world?
Drufo is used all around the world, but it is banned in the EU and a few smaller countries.
To your knowledge, why is it banned in the EU?
Based on my research, the European Union has a ban against nitrogen in fertilizers due to environmental safety risks.
Does Lush Fertilizer contain nitrogen?
While Lush Fertilizer does contain nitrogen, Drufo's properties as a bonding agent means that it is the safest product on the market for both consumers and for the environment.
Finally, Dr. Williams, let's move on to talk about how all of this relates to the plaintiff today. Did you hear Mr. Weir's testify?
I did.
Did you hear Mr. Weir's testify to using other fertilizers than Lush Fertilizer?
I heard that too.
Do you know what's in other fertilizers?
I don't. How could I? And for that matter, how could the plaintiff?
Do you know what's in Lush Fertilizer?
Based on my research, I know that Lush Fertilizer contains the revolutionary product Drufo. That, in my expert opinion, Drufo is safe. Lush Fertilizer is safe.
How do you know that Drufo is safe?
I know that Drufo is safe because my team and I have run countless scientific studies comparing Drufo to other fertilizers, and all the data from those studies pointed directly to Drufo's safety.
Why do you compare Drufo to other fertilizers?
That's good science. Good science compares apples to apples. A study that would compare, say, apples to oranges, well, such a study would simply be invalid.
What's an example of a study that would compare apples to oranges?
Unfortunate example of such a study is Dr. Rogers' study on Drufo.
Did you hear Dr. Rogers testify today?
I did, yes.
And have you reviewed Dr. Rogers' study?
Yes, I have.
And why is Dr. Rogers' study invalid based on your expert opinion?
In my expert opinion, Dr. Rogers strictly looked at Drufo in her study. This created an incomplete data set and an invalid study.
Does this study relate to the plaintiff at all?
Yes, of course it does.
How?
Well, contrary to what Dr. Rogers said on my examination of a study, I saw that she had no possible way of controlling what chemicals her test subjects were exposed to. Similarly, we have no idea what chemicals the plaintiff was exposed to while using the multiple other fertilizers at his job at Havens Landscaping.
And finally, Dr. Williams, in your expert opinion, is there a statistical correlation between Drufo and non-Hodgkin lymphoma?
Yes, in my expert opinion, there is no statistical correlation between Drufo and non-Hodgkin lymphoma. There is simply no evidence, no logic, and no probability for any other conclusion.
Thank you, Your Honor. No further questions.
Simpson? Cross?
Yes, Your Honor.
Now, Dr. Williams, you've only been working in the agriculture industry for about a decade.
Well, I've worked at Lush Fertilizer for roughly a decade, but I've worked in fields relating to agriculture, such as toxicology, pharmacology, and medicinal chemistry for 28 years since 1993. It's been a real journey to get to where I am.
Well, when Lush hired you, it was your first job in the industry, wasn't it?
Well, I gotta say it's the best job in the industry that I've had.
So that was a yes to my question?
Yes.
And in Lush's first few years, they had a hard time keeping on employees. Isn't that right?
Well, I wasn't actually employed at Lush Fertilizer in its first years of being a company. I was only employed in the 2010s, and Lush became a company in the early 2000s. So I don't know the exact specifics of that answer, but if you could ask a more specific question, that would probably help me answer.
Dr. Williams, have you ever said in Lush's first, have you ever said that half of the Drufo development team had already moved on to outside ventures in Lush's first few years?
Oh, thank you. You're referring to that. Yes, that's more clear now. Yes, by the time that I had been employed by Lush Fertilizer, been a decade since Drufo had been developed, and thus a majority or about—
Objection, Your Honor. This witness is being non-responsive. I asked a properly framed yes or no question, and they have gone far beyond that. I would like to take this time to remind the jury and the judge and Your Honor that mock trial is a time competition, and if opposing counsel thinks that this information is important to get out, they can do so on redirect.
So you're asking me to direct the witness to answer the question?
Yes, Your Honor.
Okay. Dr. Williams, if you please directly answer the question and not expound beyond that, your counsel will have an opportunity to redirect.
Yes, Your Honor.
Dr. Williams, when you joined, half of the Drufo development team had moved on to outside ventures. Isn't that right?
That's correct.
And Lush Fertilizer promoted you to lead the toxicology labs after only 3 years working in the industry?
It was 3 years of them seeing that I had potential and that I could lead a department, as I've been leading for the past 7 years, but that's correct.
So that was yes to my question. They promoted you after 3 years?
For 3 successful long years of being an employee at Lush, they did promote me, yes.
And as the leader of the toxicology labs, your primary focus is not on the safety of the product, is it?
My focus is on the product at large, whether that be the safety for consumers or safety for the environment.
Well, your main job is to oversee work on environmental impacts, right?
That's one of the main components of my job, yes.
Now, I want the jury to understand exactly what the problem is with nitrates and what Drufo does to solve that, at least environmentally. Now, we can agree that Drufo is a potentially toxic chemical agent, can't we?
Anything is a potentially toxic chemical if it contains various complex chemicals, and that does pertain to lush fertilizer as it is a very complex combination of chemicals.
So that was a yes to my question?
Yes.
And Drufo contains, or in your product contains nitrogen, right?
That's correct.
Now, in other companies' fertilizer, the excess nitrogen interacts with the bacteria around it, creating nitrates, correct?
That's correct.
And those nitrates are harmful to people's health and the environment, right?
Would you like me to go further in depth as to why they're harmful to humans and the environment?
No, a simple yes or no will suffice. Yes or no, those chemicals are harmful to people's health or the environment, right?
Yes, and other fertilizer, the nitrogen that turns into nitrates when interacting with bacteria is harmful to humans. But it's not the case with Drufo, and that's why it's revolutionary.
Now, comparing that to Lush fertilizer, Lush is sprayed in the air towards the plant by the customer, isn't it?
Lush is a spray fertilizer, yes.
And when your fertilizer is sprayed, it sticks to the things it's sprayed on because of the Drufo, right?
Yes, Drufo is a bonding agent, sticks to the plant and it doesn't let go. It's a great product because of it.
So Drufo acts as a super glue, right?
That's one way to put it.
And you have not produced a study of the prolonged exposure of nitrogen that's been essentially glued to somebody's body when they have sprayed your product, have you?
The product glues to the plant. It does not have any properties that glues to a human's body. And if you do have it researched, I would love if you were to point that out to me. So we here at Lush can further run the studies to ensure our product safety.
So you have not conducted a study, right?
I have not published such a study. However, the studies inside of our Lush have not been revealed to the general public, and since they contain proprietary information, I can't reveal to you whether I personally have conducted such a study.
So exactly. Your research related to Drufo has been within the company, hasn't been published, has it?
That's correct.
And the jury doesn't get to review any of that research today, do they?
Seeing as there is an employee of a competitor to Lush Fertilizer in court today, we saw it unbecoming of us to release proprietary information into the public.
Dr. Williams, I'm gonna instruct you to answer the question directly.
Yes, Your Honor.
Okay.
So
You want to re-ask the question, Ms. Simpson?
Yes, Your Honor. So the jury doesn't get to review any of that research, do they?
None of our research with our proprietary information is in court today, no.
Now, if you take a group of people who have used Drufo products, some of them will develop non-Hodgkin's lymphoma, right?
Well, if you take any number of people that have done anything, some of them will develop non-Hodgkin lymphoma that's not particularly containing to Lush Fertilizer.
Yes, but if you take a group of people who have specifically used Drufo products, some of them will develop non-Hodgkin's lymphoma, correct?
Statistically speaking, a small, incidental, and frankly inconsistent random chance of people will develop non-Hodgkin lymphoma, but that has nothing to do with Drufo or its chemical components. That's simply a random chance.
So that was a yes to my question. Some people will develop non-Hodgkin's lymphoma.
Some people in the world develop non-Hodgkin lymphoma, yes.
Some people who use Drufo products will develop non-Hodgkin's lymphoma, right?
Statistically speaking, a very minimal amount of people interacting with Drufo will develop non-Hodgkin lymphoma.
Thank you. Your Honor, I have no further questions.
Okay. Ms. McDermott, redirect.
Yes, Your Honor, briefly. Dr. Williams, why are none of Lush Fertilizer's studies in court today?
Well, they contain proprietary information, or in layman's terms, they contain the secrets or the information as to how to build your own Drufo, if you might say. And seeing as there is an employee of a competitor in court today, we decided as a company not to release these studies to the public so that our competitors couldn't publish this into their own fertilizers.
Thank you, Your Honor. No further questions.
Simpson, any recross?
No recross necessary, Your Honor.
Okay, thank you. Ms. McDermott, anything further from the defendants?
No, Your Honor. The defense rests.
Okay, we'll now turn to closing statements. Let's see. Ms. Feeney, are you providing the closing statement for the plaintiff?
Yes, Your Honor.
Okay.
Before we begin, may I have permission for my trial technician to display the jury instructions throughout the course of my closing?
Yes, that's fine.
And may I reserve, at this time, I reserve any remaining time for rebuttal.
That's fine. Timekeeper will advise you your time left.
May it please the court?
You can proceed.
Profit over people. Today, you heard how Lush Fertilizer Incorporated used Drufo in a revolutionary way that essentially glues a carcinogen to someone's skin. You heard how someone who uses Lush fertilizer regularly is 10 times more likely to develop non-Hodgkin's lymphoma and environmental cancer. And you heard how Lush prioritized profit over people, ruining the life of 20-year-old Dakota Weirs. In a few minutes, the court is going to read you the jury instructions, which will help you make your decision in today's case. First, jury instruction number 1 tells you that both sides had to prove their claims by a preponderance of the evidence, which is simply a legal term for more likely than not. Think about it like the scales of justice. If the evidence leans even slightly more to our side, you must find in our favor. Next, jury instruction number 2 tells you what exactly we as plaintiff had to prove. That Lush Fertilizer Incorporated's negligence caused Dakota Weirs' non-economic damages. We've met our burden. 1, we proved that Lush manufactures Lush fertilizer, which contains Drufo, as it says right on their label. 2, we proved that Lush did not exercise reasonable care to prevent their product from causing cancer. You heard of several independent studies that found Drufo to be carcinogenic. You also heard that people in Dakota Weirs' line of work often can't use proper protective gear, and that Dakota used the products in the same way under the same conditions as his coworkers, because no one knew that Lush could cause anything more than eye irritation. 3, we proved that Dakota Weirs is someone the defense should have reasonably expected to use their product as the legal employee of a landscaping business. And 4, by using Lush fertilizer in the same way as other people in the industry, Dakota Weirs was diagnosed with non-Hodgkin's lymphoma. You heard today from Dr. Rogers that Drufo caused Mr. Weirs' cancer. We know that Drufo is carcinogenic, but Lush Fertilizer Incorporated's willful ignorance caused significant non-economic damages. That's why I come before you today asking for the maximum amount of non-economic damages, $500,000. This amount is justified because using Lush fertilizer destroyed Mr. Weirs' quality of life, his independence. Even testifying has been a major inconvenience because of the physical pain he's in. He can't even play piano. His passion, his future. The emotional distress and trauma this has cost him is immeasurable. And remember, not only should the defense have known their product was carcinogenic, they did know. Their own scientist expressed concerns Their own internal study recommended baking Drufo to eliminate the risk that it could cause cancer. But Lush Fertilizer Incorporated chose to ignore the risks, the concerns, and the recommendations because doing otherwise would have been too expensive. Because they chose to put profit over people. Now it's time to hold them accountable. Thank you.
Thank you, Ms. Feeney. Ms. Wu,
Yes, Your Honor.
you can proceed.
May it please the court?
Go ahead.
Speculation versus science. Your Honor, members of the jury, the plaintiff is basing his claim against Lush on speculation versus science. The plaintiff is speculating to what caused his condition, but the defense presented you with the scientific evidence that proves the exact opposite. When Ms. Doncourt founded her company, she wanted to make a greener and healthier place by creating the safest fertilizer on the market. And she did. How? By conducting countless studies over the course of multiple years. Studies that found Drufo significantly increases the safety of the fertilizer. Let me tell you about the science behind that. You heard Ms. Skyler-Weirs testify that because of Drufo, there's less need for Lush fertilizer to be applied as often. So there's less exposure to harmful substances. Less harmful substances in the water, the soil, and in humans. That's science. You also heard Ms. Weirs testify that there is no causal link between Drufo and cancer. You heard Dr. Williams confirm that. His expert conclusion based in data that there's no statistical correlation between Drufo and non-Hodgkin lymphoma. There's simply no evidence, no logic, no probability, and no science. You also heard Ms. Doncourt did her due diligence. Lush Incorporated ensured the labels on her fertilizer were in line with EPA standards. But how can there be a warning for something that doesn't exist? You also heard Ms. Doncourt testify that the email Ms. Durst's claim is relying on is fabricated. In fact, the plaintiff's lawyers didn't find any email of the sort in the company's email system. It wasn't ignorance, it wasn't willful, and it certainly wasn't hidden. The plaintiff claims that Lush put profit over people. However, you heard Ms. Doncourt testify today that customer safety is our first priority. The burden of proof in this case lies with the plaintiff. They must prove each and every claim by preponderance of the evidence, which means more likely than not. They have not met that burden. Their evidence fell woefully short. Let's talk about that evidence. You heard from Ms. Durst, a disgruntled ex-employee who is now working for the biggest competitor of Lush, a competitor that will stand to benefit if the trial goes the way Ms. Durst wants it to. She's here with 19-year-old information she didn't even make known while it was her job to do so. Let's look back at the lack of science in the plaintiff's case. You heard from Dr. Rogers about a skewed study and an incomplete data set. So how can it be valid? It's not science. Finally, today through our affirmative defense, you also learned about the plaintiff's negligence. You heard how he was instructed multiple times to follow safety protocols. The protocols on the labels of the variety of chemicals he used, the protocols his boss told him to take, and the protocols on the Lush label. The plaintiff's own expert witness confirmed that her safety recommendations are the same as Lush's, the same ones the plaintiff didn't follow. He had to take one step to protect himself and wear protective clothing, but it was too hot. It was an inconvenience. In fact, you heard the plaintiff testify he used numerous fertilizers in this way. Fertilizers the defense knows nothing about, nor for that matter, does the plaintiff. There are too many possibilities because of his actions, and there's too much room for speculation. He knew those protocols were for his safety. Those recommendations were for his safety, and he chose to ignore them. Speculation versus science. The plaintiff is basing his entire claim on speculation. The defense's is based in data, in probabilities, not possibilities. That is science. And while this is an unfortunate circumstance, the plaintiff's ask of $500,000 in damages are unwarranted. In fact, there can be no compensation without causation, and the plaintiff has not shown causation. Thus, we ask you today to deny the plaintiff's speculative claim and return your verdict in favor of Lush. Thank you.
Thank you, Ms. Wu. I'm sorry, was it Ms. Feeney or Ms. I can't remember who was doing the closing. It's Ms. Feeney, I believe.
Yes, Your Honor.
I think you have 1 minute and 3 seconds left. If the timekeeper could please confirm that.
Yes, Your Honor. There's 1 minute, 3 seconds remaining.
Okay, Ms. Feeney, you can proceed.
May it please the court?
Go ahead.
Yay, you heard about science and speculation. But which is which? You heard the science, the multiple independent studies that found Drufo to be carcinogenic. And then you heard the speculation, as Skylar Weirs drew conclusions from inconclusive studies. And the defense tried to pin Mr. Weirs' cancer on not wearing protective gear that, as you heard from Dr. Rogers, might not even protect him from cancer. What's not speculation is that Lush prioritized profit over people. Find Lush Fertilizer Incorporated solely negligent and award Dakota Weirs $500,000 in damages. Thank you.
Thank you. Thank you, everyone. If the scoring judges can complete their scoring sheets. Elizabeth, we have until 4, correct?
That's correct, yes.
Okay. If the scoring panelists can, I see that Ms. O'Connell's is done. Is that correct? Is everyone else's complete?
Yes, Your Honor.
Ms. Smith, is yours complete?
It's not. I just need 1 more minute.
Oh, that's fine. That's fine. I just
Thank
wanted to
you.
not try to rush you.
Okay, mine's submitted.
Great, thank you. Can I have all the participants please turn on their cameras so we can see your faces? Okay. First of all, I just want to say thank you all for doing this. very impressive to see the amount of work you've put in. I'm an administrative law judge for the state, and I do 4 or 5 hearings a week, and I would be happy to have any one of you appear in my court. A couple of things I'm glad I don't have to score these things as the judge, because it's difficult, because you were all very, very good, and I was very impressed with everyone's presentation in this case. One of the things that I think is difficult for people learn, and this is difficult for lawyers who've been practicing for a while to learn too, is sort of the presentation skills that are involved in a trial. And what I really appreciated about all of you as attorneys in this is that your style, the style that you had was very conversational, and that's tough to develop that skill as opposed to just being married to your notes and asking questions based on what's written down. So I thought all of you did a very nice job of especially on direct, because direct is, people think it's easier. In my view, and maybe some of the other panelists can chime in on this, in my view, direct oftentimes is more difficult to make sound natural and to direct the witness in a way that the evidence comes from the witness without the lawyer being the star of the show. And I thought that you all did a very nice job of that, of letting your witnesses get the evidence in. There's a lot of times that lawyers who give directs, and I think this is probably common in all lawyers, most lawyers like to hear themselves talk more than they like to hear other people talk. And that's a hard habit to fight. And I thought you all did a very nice job of that when you were eliciting direct testimony from your witnesses. On cross, I thought you all did a very good job of that as well. I think cross is sometimes easier, and I think it's more natural because you have to listen and ask the questions that come naturally rather than just reading off of a piece of paper. So that's also, I think, a difficult skill to master, but I think you guys all did an excellent job of that as well. The one thing I would say, and I can't think of a specific example, is sometimes in cross, we get so caught up in making one specific point that we belabor that point to the point where we lose the point. And oftentimes when some of the witnesses weren't giving direct answers and things like that, sometimes you can let the witness be their own worst enemy. And it's not necessary that you as the lawyer, you're sort of directing this. If this were a play, you're the director or the narrator of that. You're not the star of it. And you've got to, as a lawyer, if you can have the other side's witness be sort of the villain and let them make themselves sound bad, then that's a good thing to do. So sometimes I think it's best to let the witness, if the witness is not answering and it's clear that they're not answering, let them do that, because a lot of times it's very obvious to the jury when they're avoiding the question. And I think, we talked about this a little bit during the hearing of it's important for you as the lawyer to ask the court to intervene when the witness isn't being direct, in part because that helps your rep. You don't look like the bad person then, right? You don't look like the person that's bullying the witness. You can make me be the bad guy. Okay. And if you think about it, if the witness isn't answering, you can get the judge to say, Dr. Williams, just answer the question. That's way better than you saying just answer the question, because now it's like 2 against 1. So just technique wise, I think, and you all did a nice job of that. I have to say, I was very impressed with both the openings and the closings from both sides. Miss Feeney, I really liked on your rebuttal how you thought on your feet and really came back and sort of use the defense's own theme in your rebuttal. And I think that was very savvy to do. And I thought it was very well done. Overall, I would just say, I don't want to take too much of your time because I know you folks that we're supposed to be done here in a few minutes, but you can really tell the amount of work that you all put in. And it's impressive. This is not an easy thing to do. And I think you all made it, it looked very easy and natural. And so overall, very good job. There's nothing that I wrote that I could think of that I would offer a great deal of criticism on. But so good job and congratulations on getting this far. So I'll turn it over to any of the panelists that would like to offer any feedback.
Just briefly, first of all, I thought our presiding judge did a really good job of controlling the courtroom in this round, so that was awesome. So yeah, outstanding opens and closes. I thought those were absolutely practicing attorney quality. I guess I should tell you, I'm a trial attorney. I did high school mock trial, and now I'm a practicing trial attorney. And I practice in another state where we try cases a lot more often than here. And there are lots of attorneys that do not do opens and closes nearly as comfortably and as well paused and inflected as you guys did. That was incredible. I think there's so much power in the pauses and the inflections and the timing. Also an incredible grasp on the rules of evidence for where you guys are at your stages in learning. I've done I've judged some college rounds where they don't have that grasp of the rules of evidence. Continue to work on that because that really sets you guys apart. Also a good use of demonstratives and not overusing them. You could probably use them a little bit more if you do it well. Don't overuse them, or if you don't use it well, then just scrap it. I agree. Don't interrupt your witnesses or talk on top of them or go back and forth with the witnesses if things aren't going well. Learn how to either properly direct your question or politely ask the judge. Don't show your frustration as much. Just let the judge handle that because that will reflect better to the jury. And the I heard a yes thing, it really grated with me. Every time I heard that phrase, it really grated with me, and it will with a judge in real life. It will with a judge in further rounds and in college rounds and in law school rounds. Try to do things like end your question with right or correct, and then start the next one with, if you wanted, instead of doing I heard a yes, start your next one with right, and because of that, or yes, and so, instead of saying I heard a yes, just say right, so, correct, so, yes, and because of that, just to do a better, more sort of cordial way of saying that yes. Does that make sense? Anyway, great job, guys.
Ms. Smith?
I was just thoroughly impressed with all of you. The amount of work you put in what showed, and I just appreciate so much that you all put in as much work as you did, and I was just really impressed. And I agree with everything Ms. O'Connell said. I too think that you can lose the emphasis you're trying to make when you belabor the point. So just, yeah, be a little bit careful with the cross-examination piece, but yeah, you all were amazing and you should be really proud of yourselves.
Mr. Monk?
Good afternoon, everybody. I am Lieutenant Nicholas Monk. I am a JAG in the United States Navy, so I am a naval officer and a practicing criminal defense attorney. I'm actually coming to you today from Pearl Harbor, Hawaii, where I am stationed, though graduated from the University of Colorado Law School, where I competed in mock trial and competed in various public speaking and debate all through middle school, high school, undergrad. Really nice job. I understand that I'm the last judge standing between you and awards and finding out who broke. So I will not, this is not the time for lengthy feedback to change everything. I think well done, everybody. I will once again repeat what my fellow scoring panelists have said. Very impressive job. Really, especially considering that you're at the high school level and you have clearly not gone to college and clearly not gone to law school and not passed the bar exam and practiced as attorneys for years. So really very, very impressed with where you're at. And clearly everybody deserved to be here at the state final competition. So well done. Best of luck if one or both of you do advance on after this round. Best of luck.
All right. One final thing that I was going to say, and I meant to raise this, it's with respect to, well, Skylar Weirs would never have been admitted as an expert in my court, probably. And I wanted to point out that there were a few objections that were made that I probably overruled that in a real court I would have sustained, and I didn't sustain them here because I think it would have cut, because of the competition, you know, it would have cut somebody's testimony in half or precluded a witness. But I was impressed with the objections that you made. None of them were, even if they were overruled, they were all you probably would have won on a lot of them in a real situation. So I wanted you guys to let you know that. So keep making them because they're valid objections. It's just you got a judge that wasn't going to grant them, and that's not your fault. So good luck to all of you. You're all excused. Hopefully, good luck for you all in the rest of the competition. Again, you should be very proud of yourselves, and thank you very much for being in the competition. Have a great rest of your weekend, everyone.
Thank you.